Thank you, everyone. My name is David Kinsey, and I am the director of the International Cross-Border Investment Management and Financial Planning Group, Thun Financial, a part of Creative Planning. And I am here joined by my colleague, Roger Healy, and we are going to be going through a webinar today on key estate planning concepts and issues for U.S. expats and cross-border families. Thank you all for attending, and we're looking forward to a great presentation today. Just a couple of notes before we begin. This presentation is being recorded, and everyone who attends will get a link to the replay afterwards. So if you miss something, or if you want to review anything that we've discussed here, you can just watch the replay. You can also feel free to share it with anyone who you think might find it of use as well. We are going to be having an extensive question and answer session at the end of the presentation, as we always do. And I will say that we generally try to go through all of the questions that are put on the question and answer box. And so it takes a long time, but we will get to your question eventually. If you want to make sure it gets answered, you will be assured that it will. So go ahead and you can start entering questions or put them in as they arise in your mind as we go through the presentation. And we'll look forward to a great question and answer session. So let's lay out an outline of the presentation, and then we'll get going. We're going to begin by talking a little bit more about Thun Financial Advisors and Creative Planning for those of you who are new to our firm. Then we're going to talk about the goals of estate planning, and Roger Healy will take over at that point. He will then talk through multinational estate planning, probates, trusts, foundations, and other devices used in cross-border estate planning. And we're going to talk about the implications of national laws on transfer taxes, that's estate, inheritance, and gift taxes. Then we cover the critical issue of tax treaties and credits, how they work between countries. We then go through a couple of very common cross-border estate planning scenarios that we see over and over here at Thun Financial in the many years that we've been working with clients around the world on these issues. And then we come back to the question of putting cross-border estate planning in the context of multinational investment management. And then we will get to the questions and answers. So quite an agenda here today. Thun Financial Advisors is an investment management and financial planning firm. We operate as the international advisory group within our parent company, Creative Planning. We build comprehensive approaches to building long-term wealth customized for the needs of expatriates around the world, mostly American expatriates, but not only. Our client base is therefore, not surprisingly, very global. We have clients in over 60 countries. Creative Planning and Thun Financial Advisors are registered with the Securities and Exchange Commission. We are a fiduciary to our clients, and that's a very important concept. I won't elaborate on it here, but please feel free to contact us, and we'll talk more about that in terms of how we operate effectively for our clients as investment managers and wealth managers. All right, about our parent company, Creative Planning. Creative Planning is always ranked as one of the top registered investment advisories in the United States, has been ranked #1 by Barron's as recently as 2017. They manage cumulatively $69 billion of assets as of the end of last year. We have 32 offices in over 20 states. Of course, they are a fiduciary, as are we, and they work with custodian institutions, TD Ameritrade, Schwab, Pershing, and Fidelity. And we're not going to be talking a lot about that, but I know it's always a critical issue. Can I get and maintain accounts? And with us, it's absolutely never a problem. All right. Our team at Thun Financial, within the broader Creative Planning, our team is a dedicated team to working with Americans abroad and cross-border families. We have tremendous expertise here that ranges from law to professional investing to accounting to tax preparation to, of course, financial planning and financial advising. All of us have extensive experience in one or more of those disciplines. And most importantly, most of our team has experienced what it is to be an American abroad. They've lived abroad, they have cross-border families. So I think we understand it not only from the technical aspects of delivering services, but also from having lived the experience, and oftentimes the frustrating experience it is to be an American abroad or have a cross-border financial life. All right, our firm has received tremendous recognition, that is Thun Financial, for its expertise in this area. All of these well-known media outlets have quoted us or featured us. I myself, David Kinsey, have been a contributor for many years to the Wall Street Journal's Expat review on matters related to expat investing and financial planning, and so we're very proud of that coverage. All right, let's talk now, as before we get into the technical aspects of cross-border estate planning, let's put cross-border estate planning in the context of broader cross-border wealth management. When we talk about wealth management, we're talking about what we do here at Thun Financial Advisors, which is to integrate financial planning with investment management to provide a holistic approach to building wealth securely in a coherent, compliant, and tax-efficient way. Within that holistic approach to investing and planning, estate planning is a key component. Why is it key? Because it is a fundamental part of the wealth management process whereby we arrange our affairs in a way to pass our wealth ultimately on to our heirs and beneficiaries. Unfortunately, this is one of the areas that is extremely poorly understood when we add in the cross-border aspects of estate planning by traditional advisors. But as we'll see, the consequences of making mistakes here can be immense. And we often see firms that are otherwise very, very good at what they do. When they take on clients who are cross-border clients, the advice they give them is inevitably wrong because they do not understand the interaction between the US rules and the country of residence rules with respect to estate tax, probate, the rules of succession, and so on and so forth. Our firm's dedication in terms of integrating in planning and investing and estate planning is to bridge that gap and make sure our clients around the world not only get efficient investment outcomes and financial planning outcomes, but their assets are positioned effectively to be passed on to the next generation without excessive complication, without excessive taxation. And that's the goal of integrating wealth management into good financial planning. So with that introduction, I am going to turn it over to my colleague, Roger Healy, who's going to be walking us through the bulk of the presentation. Roger has many, many years of experience in investment management and estate planning and cross-border taxation. He brings a tremendous knowledge and expertise that he has shared over the years in his many roles, including as a professor of these issues at NYU in New York City, among others. So, all right, with that introduction, I turn it over to Roger.
Thank you very much, David. Good morning, everyone. Good afternoon, good evening, depending where you are. The question, first question really is, well, what are some of the goals of estate planning? Briefly, I think the goal is to be nice and relaxed, like our panda bear friend there. We're trying to transfer our assets to the beneficiaries that we want to receive them. We want to do this as tax efficiently as possible and as cost efficiently as possible. So we want to minimize legal, administrative, and in particular, the amount of time it takes for all of this to happen. And then these days, we'd also like as best we can to maintain as much privacy as we can in these affairs. Thanks. Now, what's different then when you get into a multinational estate planning context? Well, the first question is going to be what succession laws are going to apply to my assets? If I've got stocks and shares in the US and I've got real estate in another country, how are they going to devolve to my heirs? And which country or countries transfer taxes, so estate, gift, inheritance tax, etc., would apply to my assets? Will my wishes be respected, or will there be rules within my country that state how my assets are to be inherited? And back to that cost question, how much will it cost and how long will it take? Next slide, please. Now, the crux of the problem lies in the different legal systems that exist in the world. Now you see the sort of salmon-colored ones here, you know, the United Kingdom, Ireland, Canada, the US, Australia, New Zealand, and lots of little islands, are based on the British common law system. Then you'll see a large amount of blue, which are the civil law, the Napoleonic Code countries, and they have a very different interpretation. For example, the common law system, you know, foundationally has the use of trusts in it, and civil law countries don't recognize trusts at all. Now they've started to, they try to through convention and other means, but it's a fundamentally alien concept. So you can see that, you know, if you're leaving somewhere like the US with your estate plan, there aren't a lot of jurisdictions you can go to which will immediately recognize and understand the concepts within your plan. You know, in Middle East and North Africa, that green color are Sharia law countries. So, you know, you can see around the world, you've really got to understand where you're going in order to put together a good estate plan. Next slide, please. So the most basic estate planning document you can have is a will. And that will only becomes effective through the process of probate. And probate establishes whether the will is valid and enforceable. Now, wills are common in virtually every country. And the questions that arise are, is your will compliant with the laws that apply to your assets? Can the person you appointed as executor get a grant of probate or letters of administration in the country in which your assets are located? And how likely is it that your will be challenged? If your will is in complete contravention of local law, it may be very open to challenge, and those challenges may be readily accepted by the courts in those countries. Can you avoid the probate process? Can you pass assets outside of your estate? Now, in the US, one of the most common methods to do that is through beneficiary designations on retirement accounts. But what if those beneficiary designations are adverse to the laws of your home country? So, you know, let's take, for example, a country that has forced heirship laws, where there's a hereditary reserve for, you know, children and spouses. If 98% of your assets are in your IRA and you leave that to one of your children or to your spouse, you're likely to have breached that forced heirship rules, and you may find you know, significant challenges in the other country. Will it work from a US perspective? Yes, but are there other assets that now may suddenly be attached as part of this litigation? What if your will is simply invalid? Then what happens? So in most countries, next slide please, what happens is an intestacy process. An intestacy is where there is no will, or it's not enforceable. Now, every country has some form of intestacy laws, some system whereby assets are dealt with in the event that someone dies without a will. And those laws often dictate who inherits. In some cases, if it's not obvious who inherits, the assets may in fact become the property of the state. So, you know, what are the circumstances in which that will happen? Next slide, please. So there are some really useful tools. Probably the one that we see most commonly used by American expats is the EU regulation known as 650/2012. And this regulation creates a European certificate of succession. It's a testamentary election, so therefore within your will, where you state that you want the probate and succession laws of either your country of residence or country of which you are a citizen to apply. Now, if you're a US person, you'll have to, you know, drill down a little further because there are no probate and succession laws federally. They belong to the states. So you'll need to pick a state with which you have sufficient ties and elect that those laws will apply to your to your state. Now, importantly, This is not a tax planning device. This will have no effect on any inheritance taxes or estate taxes that are payable by your estates. It specifically states it does not apply to trusts. You cannot say, well, I want the succession laws of, of California to apply, and I want therefore to be able to use my California trust. That's not going to work. Now, when this came into effect in 2015, Denmark, Ireland, and the United Kingdom opted not to have it apply. So if if you're looking at one of those countries, this isn't an option for you. But in most of the rest of the European Union, it is a very useful tool that can be used in your planning. Next slide. Now, other mechanisms are things like transfer on death designation on an account, whereby you say, on my death, the account should transfer to this person. Now, importantly, those are very common in the United States, but they are tied to state law. And so if you're not resident in a particular state, you may be entirely unable to claim the ability to use that state law's transfer on death legislation to allow you to use this rather useful mechanism. And it also, as stated with the designated beneficiaries concept, it may fall foul of your resident country's forced heirship rules or other laws. Joint tenancy and ownership of an asset, that can have intended and unintended consequences. So it's definitely worth thinking through. It may be very effective. It may not necessarily breach your rules, but it's not a guaranteed solution. Insurance is probably one of the most complex areas, but in general, life insurance is understood and accepted throughout the world. So simple term life insurance can be a very effective way of getting assets to people, or a very effective way of providing liquidity, either for ongoing living needs while the estate goes through probate, and it may also then provide liquidity for paying things like estate or inheritance taxes. Insurance wrappers, on the other hand, are very problematic because they normally involve some kind of an investment. And insurance wrappers don't get treaty protection. They are looked through to the underlying investments, and those underlying investments in non-US insurance products are often passive foreign investment companies, which have very terrible tax consequences, which is another webinar within itself. Gifting. So gifting is another area where you really have to watch two systems at once. So in a lot of countries in Europe, they have maximum gifting based on time periods. So the amount you can gift within a decade or within 15 years, or you need to gift and survive a number of years. In the US, you're limited to gifting $15,000 per donor per recipient. Now, so in the US, you can give away large amounts of money to large amounts of people without any tax or reporting requirements. But you really have to manage that intersection, that overlap of two systems to do this efficiently. Family agreements have become increasingly popular in civil law countries, but there's often questions as to their enforceability and the ease with which they could actually have entirely the opposite of intended effect and give rise to litigation on the death. Next slide, please. Now, I wanted to talk briefly about trusts. So trusts are very common components of US estate planning. They're very common components of estate planning for non-resident alien investors in the United States. They're very effective, but their tax treatment is very much a matter of US tax code, and what may be a very beneficial structure in the US may not work particularly well from the perspective of the country in which you are resident. So a typical trust, the settlor contributes assets to the trust. It holds them perhaps through one or more investment companies, and those investment companies hold various assets. Can be real estate, can be stocks and bonds. In any proportion it likes. Trusts are often established to provide income for lifetime beneficiaries, such as a surviving spouse, and then to distribute completely to contingent or discretionary beneficiaries, which could be charities or children. There is no end to the complexities that can be built into trust structures. Next slide, please. Now, we won't spend too much time on this slide, but these are just some of the trust structures that are really spelled out and have and for which there are great benefits provided for by the U.S. tax code. The first few items up here to kind of get you some familiarity are grantor or non-grantor. So a grantor trust essentially is a trust where the tax burden, including the inclusion of the assets within the estate, are borne by the person who's given the assets. Non-grantor generally means that the grantor no longer has any tax liability for the earnings within the trust. Revocable or irrevocable is fairly self-explanatory. Either you can undo or not undo what you've just done in terms of setting up a trust. A testamentary trust is one established within your will, whereas an inter vivos trust is one that you establish whilst you're alive. Foreign or US domestic is a matter of, if it is a domestic trust, it has to satisfy a court test and a control test. In other words, the US has both legal and practical jurisdiction over the trust. And if it's not a US domestic trust, then it is a foreign trust if it fails those tests. Very common in the US are revocable life insurance trusts. These can sometimes be useful outside of the United States. They can also be very difficult to undo. They are irrevocable by definition. A QDOT is probably one of the most commonly used terms in multinational families where you have a US citizen and a non-resident alien, or as the US government is now increasingly referring to, a non-resident non-citizen as the spouse. Then assets may pass from the US citizen into the QDOT for the benefit of the non-resident non-citizen, and that preserves the estate tax transfer between spouses on an unlimited basis until the death of the second to die. So QDOTs can be common, but we'll talk about some of the misconceptions around those later. The remainder of these trusts here, QTIPs, GRATs, QPRTs, IJITs, etc., are complex tools which can be very useful for very large estates. And if that's you, by all means give us a call. We'll be happy to discuss some of the benefits that may accrue to you using this. Next slide, please. Actually, just before, so foundations are a common law version of a trust. Is probably the simplest way I can describe them. And they are brought into existence through legislation rather than through centuries of legal history. Now, most important topic for many people is the issue of estate inheritance and gift tax, so transfer taxes, as they're collectively known. In the US has estate, gift, and generation skipping transfer taxes. Now, we won't talk too much about those, but they apply either to where you are skipping a generation going from grandparent to grandchild, or you are going to an heir that's 37.5 years younger than the decedent. You may then invoke generation skipping transfer taxes, which effectively is another round of estate taxes. So you start with $100, you pay $40 in estate tax, and then you pay 40% of the remaining $60 in GST taxes. So they can be really significant if not properly managed. In the US, many states have state inheritance taxes. So this is really where you need to think about, what are you doing that might make you resident or a domiciliary of a state, and are there things that you need to do to stop being domiciled in a state that has inheritance taxes? And then what about the country you live in? Well, as we'll see, an awful lot of countries have either an inheritance or an estate tax, and that can apply to the worldwide assets of the decedent, or importantly, it can apply to any receipts of residence. So you have a child who now lives in a country with an inheritance tax. When you die, whatever that child inherits may be subject to inheritance tax in that country. It's important at this point to try to distinguish between real property, so land and buildings, tangible property, artwork, jewelry, things like that, and then intangible property. Fairly self-explanatory, but importantly, including things like securities. Different countries have different rules around situs, and situs is really to say, where is that asset? So with real property, it is generally agreement that real property is situated in the country in which it actually exists. Not too much argument over there. But what about artwork? What about artwork on a yacht? What country is that in? And then what about intangible property? So what are the situs rules that are going to apply to your asset, and are any of them modified by treaty or other convention? Next slide, please. So U.S. estate and gift tax is the one that I think everyone is most familiar with. So the tax is payable on the taxes are payable on taxable bequests. So either through a will or as a lifetime gift on the worldwide assets of a U.S. citizen or other U.S. domiciliary. For a non-U.S. domiciliary, the tax is only payable in relation to U.S. situs assets. A U.S. citizen has a unified exemption amount. Unified means it's can be either used against your estate or your gift tax liabilities, and it's currently at 11.7 million, and it's indexed. And now, important to note is that under the Tax Cuts and Jobs Act, this large amount is only in place for 10 years, and so it will revert in 2026 to the $5 million indexed, which is estimated to be about $6 million at that point. Still a significant amount of exemption. Now, if you're not a U.S. domiciliary, the amount is only $60,000, and that's not indexed, and that has not changed in a very long time. So that's often a big flashing red light, big warning sign for many people. $60,000 of U.S. situs assets, and the balance then will quickly become subject to U.S. estate tax at 40%. Spousal gift allowances. So a U.S. citizen has an unlimited allowance to make gifts to their citizen spouse. To their non-citizen spouse, they have an annual $159,000 limit, which, as I say, is annual, so they can keep giving every year. Everyone has an annual exclusion amount of $15,000, and as I mentioned earlier, that is per donor per recipient. So a married couple with 2 children could give $30,000 from each of them, so a joint $30,000 gift to each child. But there doesn't have to be any relationship between donor and recipient. You can give $15,000 to everyone you like, and that would be one way to get rid of your entire estate. And the important part about these limits is there is no reporting requirement if you are within the limit. If you are over the limit, then you start to use up. You have to report on a gift tax return, and you start to use up some of your exemption amount, or you can pay the gift tax. Next slide, please. So the US isn't the only country with estate and gift taxes. And the US has estate and gift tax treaties with a number of countries, but really not very many. So we've listed here the 7 countries with which there's an estate and gift tax treaty, and the 8 countries where the treaties cover estate taxes only. Now, importantly, there's an asterisk beside some of these countries, and these are countries which have new situs rules. And in general, the new situs rules mean that anything other than real estate and business assets are not going to be considered to be US situs. If you are a non-resident alien relying on the treaty and looking at what are your, what assets of yours might be subject to US estate tax. So you're a non-resident alien, non-citizen living in the United Kingdom, you own an apartment in New York and you own a whole load of US securities, only your apartment in New York is going to be subject to US estate and gift taxes. And that's assuming you own it in your own name. On the next table is a list of countries and the thresholds for gifting to a child. Now, importantly, most of these countries, you can make unlimited gifts to your spouse. But if the recipient of your estate is going to be one of your children, these are the levels at which the estate tax or the inheritance tax in that country starts to kick in. Now, the first two, Australia and Canada, are relatively common for US expats, and they have quite different treatment. Australia imposes an income tax on a recipient who is not a resident of Australia, recipient of an Australian estate. Canada imposes a capital gains tax on all estates. So when a decedent dies, there's an immediate mark to market and everything is considered to have been sold, and there's a capital gains tax payable by the estate. And that is without regard to who's going to inherit. So there's this immediate capital gains tax liability for a Canadian estate. In France, Germany, Ireland, Italy, and Japan, there are inheritance taxes. So there it matters who is the recipient and what is the relationship of the recipient to the donor. And that's kind of very important to note. If at this point you find that your will or your previous planning has moved all of your assets into a trust, that trust may have no relation to your child. It may be a third party, in which case these not overly generous limits, even those collapse to much less generous limits. And then the United Kingdom has an estate tax, and the estate tax is on the exemption is for £325,000 of the estate. Important to note here, if you look at these numbers, for many US expats, US estate tax is not going to be an issue. If you have a $10 million estate and you live in one of these countries, your problem is not US estate tax. Your problem is going to be your local inheritance or estate tax, or income capital gains tax, as the case may be. Next slide, please. Now, a common misconception is, well, this is fine. I can just take tax credits. Well, one, you might not have any U.S. taxes to pay if you're below the threshold. But even if you're above the threshold, unless you're significantly above the threshold, paying foreign death taxes may not give you much relief in terms of having to pay U.S. death taxes. And someone said to me, well, step one is going to be to hire a U.S. attorney, and step two is going to be hire an attorney in your country of residence, just to figure out your foreign death taxes and whether there are credits available. Now, fortunately, there is no treaty requirement, but you need to figure out, well, what death taxes are due to the foreign taxing authority. You need to actually pay them. And then you need to figure out if they're creditable. And in general, the foreign situs needs to be the same as the foreign taxing authority. So this can cause some significant problems where you're being taxed in one country for assets that are in a third country, and the U.S. looks at it and says, well, that's nice, but we're not going to give you credit for that because the assets don't have the same situs as the taxing authority. When you finish jumping through all of that and you fill out your Form 706CE to certify the payment of your foreign death tax, you then need to get, I've deliberately put a copy of this small part of the form on the slide, you need to get this certified by a tax official of the foreign government that's imposing the death tax. So you can well imagine this is not a high-speed event in any case. Next slide, please. So we're going to go through 4 common scenarios. US citizens with non-resident alien or non-resident non-citizen spouse, non-resident non-citizen estate tax liability, so you're a non-resident non-citizen investing in the United States, taking your US estate plan abroad, so how is it going to work in a foreign country, and then issues about what succession laws are applicable. Next slide, please. So probably one of the most common scenarios we come across is where a US citizen is married to a non-resident non-citizen. It's correct, there is no unlimited spousal exemption between them. So I think it's in the many hundreds, if not thousands of people have told us, well, that's it, I can't leave assets to my spouse. Or if I do, there's going to be a 40% estate tax. My entire estate is going to be subject to this tax. That's only partially correct. You still have an 11.7 as of today, $1 million estate tax exemption, and that can be used to benefit any bequest to your spouse. So it's entirely possible that you can leave your entire estate to your spouse free of any U.S. estate tax. And only when you get over that will other assets quickly become subject to a 40% tax. And again, if you're well over this 11.7 million, maybe it's worth your while setting up a qualified domestic trust. You know, let's say you have U.S. children from a prior marriage. Now you're married to a non-U.S. non-resident. And then, you know, maybe something like QDOT will work for you. But importantly, we're going to have to think about, well, what are the rules in your country of residence or domicile, and what other estate and inheritance taxes might we then be exposed to? Next slide, please. So the non-resident alien, the non-resident non-citizen investor in the United States, they only have a $60,000 exemption, and that is simple and correct. But what are some of the solutions for it? Well, we've mentioned estate tax treaties, and you know, does your country have an estate gift tax or just an estate tax treaty with the U.S., and what does that treaty provide? And as mentioned earlier, it may provide that U.S. securities are not considered U.S. situs by operation of the treaty, in which case maybe you don't have any U.S. estate tax liability. What about the ownership structure? Well, there's a lot of people who own the S&P 500, but they don't own it in a US ETF. They own it perhaps in an Irish ETF, or they own it in a collective investment vehicle in another jurisdiction. Then they don't own the underlying investments. What they own is that first ownership vehicle into which they have invested. That can also lead to the use of what are called PICs, personal investment companies, which could be any entity that's not a US entity. Or perhaps you have several business entities of your own, and one of those owns your assets within the US. Then when you do die, you die owning that entity, not the underlying assets that it owns. Now, if you're a US citizen and your spouse is the non-resident non-citizen, there's no US estate tax on anything you receive from your non-resident non-citizen spouse. But again, that doesn't mean there's no tax in general, because that tax may actually be applied by your home country. Now you've got maybe an estate or inheritance tax payable there, but you will not have a US estate tax. Next slide, please. Now, what happens when you pack your bags and you take your US estate plan with you abroad? So many people have US living trusts, and of which they are not only the settlor, but also the trustee. Now, when they arrive in their home country, the question is, what do they have? Well, if you're in the United Kingdom, a UK resident trustee has reporting obligations, and the trusts of which they are trustee often have income tax requirements in the UK. And those are liabilities of the trustee paid by the trust, perhaps not individual, perhaps not usable for foreign tax credit purposes. So this could be very punitive. And in most countries, trusts don't get any personal allowances or exemptions. You also now have a whole collection of administrative and reporting problems. What you consider to be a US trust, because you say, well, it's under the laws of Delaware, now fails one of the control tests and becomes a foreign trust for US tax purposes. So now you have foreign grantor trust reporting requirements and perhaps new tax liabilities. Enforceability arises. Is the country in which you have this trust going to even honor the trust, or are they going to say, nope, this is just you trying to get around our local laws, there are other ways to do it, or it cannot be done, so we're just going to ignore it. And as I think you can tell, one of the things that can arise from just arriving with your foreign trust is litigation, either with taxing authorities or perhaps with disgruntled potential heirs. So again, you've really got to think about, well, how does your foreign country, how is it going to treat this US trust that you're bringing with you? And that brings us again to the topic of applicable succession law. So I think the main problem here is people don't recognize that the probate and succession laws in their new country of residence are highly likely to apply if they die resident or domiciled in that country. And the rules at the point at which you become resident or domiciled in a country for state tax purposes vary by country. In some, you'll be deemed domiciled after maybe 15 years. In others, it can be as quick as 6. In others, it can be fairly immediate. You're a resident here, therefore your estate is here. So just to go with a common example, you decide to retire in France. France is a civil law country. It has forced heirship or reserve hereditaire rules applicable to the worldwide assets of its decedents. Your US plan may not be valid under French law. Now, as I mentioned earlier, you could have a French will, and under that French will, you could elect under EU regulation to have US, a particular state in the US, succession rules apply to your estate. And then you would have a valid will that would work under French law. Now, importantly, as we like to talk about, the US is special when it comes to its citizens and its taxation of its citizens. It claims the ability to tax citizens wherever they live in the world on their worldwide income. It's important to note the US does not claim any similar applicability of its succession laws to its citizens domiciled outside the United States. It will, look to enforce its laws when it comes to the inheritance of things like US real estate. But again, if you have a valid will under your country that doesn't contravene some public policy in the US, it will be applicable and applied in the US. So this is a very different scenario from when we're talking about US income tax issues. Next slide, please. Now, how can we start to think about this when we're trying to invest assets for a US citizen and a non-resident, non-citizen spouse? And in this scenario, we're looking at a Hong Kong spouse. So we concentrate for estate tax purposes the US assets, so these are US funds or US securities in the US citizen's account. Now, Hong Kong doesn't have an estate tax treaty with the US. If we were to hold US assets in the Hong Kong spouse's name, they would immediately run the risk of being subject to US estate tax on everything after the first $60,000. So we look to hold liquidity and similar US assets in the Hong Kong portfolio. One more click, please. And you can see there we've concentrated the non-US assets in that non-citizen's account. This is a very straightforward and effective way of managing the estate tax liability and, importantly, providing liquidity to both spouses in the event of the demise of the other. In the Hong Kong spouse's account, we would likely use UCITS or other non-US collective investment vehicles to allow them to make their investments. So that's, I think, a very cross-border specific way of looking at how do we locate assets in particular accounts in order to get the best overall effect while not introducing new problems such as US estate tax into a family's affairs. And with that, I'll just let you know that we're going to have a couple of more webinars upcoming on April 1st. Kathleen Kaffer and Jake Munger will present on college saving strategies for American families abroad, always a popular topic. And on May the 11th, we're going to have a jurisdictional specific presentation on investing and financial planning for Americans in the UK. And that will cover the A through Z of investing and financial planning for Americans in the UK. And that'll be presented by Peter Sengelman and David Kinsey. And now I think it's time for a question and answer session. And David, I've got a few questions that we received in advance by email. So I'll just go through a few of those before we get to the ones that have been presented live. So the first one comes from Monica in Germany, and she wants to know, should she keep her trust? She has a pour-over will, so the assets will all end up in this trust. She has trust accounts. Obviously, her IRA that she has is not in her trust because it needs to be held by an individual. But she would look to perhaps have it devolve to maybe individual heirs or to her trust. And then she has real estate in Germany, which she's putting in her German will. She can't add it to her trust. So David, for Germany, should she keep this trust or find a different solution?
Well, I'll let you answer. Roger, what do you think?
So my immediate reaction is, no, this isn't really going to work very well for you in Germany. And you should redo your estate plan around German estate and inheritance laws and not introduce something like a US trust into the mix. It will, for example, break the link between heir and decedent. So I think this could work out rather poorly for your beneficiaries.
Yeah, this has come up over and over again for clients and people that we speak with in Germany. And the function of a U.S. trust not only does not work in Germany, but as you suggest, Roger, it now is treated in Germany as a third party, and the benefits of in terms of the exemption amounts being high when you leave to a spouse or a child go away, and now it's as if you're leaving money to a third party and the exemptions are very low, hence the tax will be much higher. So trusts absolutely do not work as an instrument in Germany.
Staying on the trust theme, Fred, who is moving to France from California, so bright early morning to you, Fred, has similarly got his assets in trusts, and they are wondering if this is the best solution for them, or if they should simplify their affairs. And then he also has a kind of follow-on question of, well, when they move to France, what are they going to do in terms of managing their accounts, as they won't have U.S. address with which to manage the account. So, again, it's a very similar story from Germany. You're not really going to want to hold your assets in trusts while you're living in France. You're not going to want to die with your assets in a U.S. trust or with U.S. pour-over wills into the trust. And France is one of those countries that is part of the EU regulation 650/2012. So you would be able to elect, perhaps California law as the reference law to devolve your assets and therefore be able to leave them to whomever you want. So that would be how I would start with that. David, you want to talk about what to do when you leave the country and you don't have an address?
Right, so France is not a problem for us. We can work with clients in France with accounts either at Charles Schwab or Fidelity. We can use the French address. We can invest for our clients through their accounts at Fidelity or Schwab with any of the instruments that we want in terms of building an effective portfolio strategy. So France is no problem.
Great. Next question is regarding a UK SIP. And this comes from a UK citizen who is not a US citizen. I'm assuming not a US green card holder, but they have two children who are dual citizens, dual US UK citizen. And under UK law, should they die before they are 75, their SIP will be inherited tax-free by their children, whereas if they die when they are over 75, it will be very similar to an inherited IRA in that it will be income taxable to the beneficiaries. So his question is, well, what's the IRS going to do? Now, I guess the first point to note is there's no inheritance or estate tax payable in the US by your children on receipt of these gifts. There's no, assuming you're not domiciled in the US, there's no estate tax payable by your estate for the devolution of this SIP. But how is it going to treat the receipt? Now, certainly if it's over 75, it will be taxable income in the UK and taxable income in the US. Your children would get tax credits for any income tax they had to pay in the UK. So net, they wouldn't have any tax to pay in the US on a net basis. Now, it's very interesting, if they die before they're 75, it then becomes a tax-free pension plan, not just a component of it. There's certainly a very contentious argument about lump sum payments that are tax-free in the UK but not tax-free in the US. But the entire pension becomes tax-free in the UK. So, I would certainly want you to consult with your US tax preparer and tax advisor. But my view would be that because the entire pension has now become tax-free, that same treatment is required of the IRS. The same way a Roth IRA, which is tax-free, a tax-free pension account in the US, is also tax-free in the UK. So by treaty, I think that if you die before you're 75, there wouldn't be any income tax payable in either country. But again, I'd get your tax opinion to confirm that.
Right, that's a great example, Roger, I would add, of where you have kind of an unusual circumstance in a counterintuitive outcome here where the assets could pass tax-free in the US, by operation of the treaty, in contravention to the U.S. principle of taxing everything, that there's a lot of gray area then, right? And this could devolve into a very close reading of the treaty and all kinds of contingent laws that may apply, that may override the obvious reading of the treaty. And we see this all the time, which is why in scenarios like this, you can have so many different opinions from very qualified tax experts about how this should be treated, and no guidance from the IRS, right? And so it's really up to you to establish your principle and then make your own claim.
Yeah.
Wouldn't you agree?
Yeah, absolutely. And I would hope that it becomes taxable because you've lived well past 75. Let's leave it on that one. So another question now from Nikki is, could we discuss the use of LLCs in estate planning? So LLCs are, what are known in the US as limited liability companies, which for people outside the US is kind of a strange phrase, because the point of a corporation is to have limited liability. But an LLC gets particular tax treatment. If it's what's known as a single member LLC, it can elect to be treated as an S Corp, which is a particular type of US corporation, or it can, its default treatment is to be disregarded for income tax purposes. And this makes it quite popular vehicle for a lot of individuals to own assets, because then the LLC itself isn't filing any taxes, isn't a taxpayer, doesn't add any extra layers of tax. If an LLC is owned by more than one person, then its default treatment is to be treated as a partnership. While it files a return, then it doesn't pay any tax. But it can elect to be treated as an S Corp and have multiple shareholders. And this then in an estate planning context, particularly in a cross-border estate planning context, is going to raise an awful lot of questions. The first and perhaps most important question is, what does your home country think it is? Does it think it's a corporation? Does it agree that it's a disregarded entity and that you own the assets individually? And then what are you inheriting? Are you inheriting, shares of the LLC? Are you inheriting the underlying asset? And what effect would that have? What perhaps does your executor need to do with this asset? And then from a U.S. estate tax planning perspective, what are you valuing? If your estate plan involves, distributing units or shares of this LLC, then it's important that you look to value the units of the LLC and not the underlying asset. There's been a fair amount of recent litigation on this, where people are making gifts of units of the LLC, but the valuation they got is of perhaps, a family property. Well, that valuation isn't necessarily applicable to the units in the LLC. So, an LLC can bring a lot of simplicity in some cases, as well as limited liability, but it can also bring a great deal of complexity. So I would, I'd use with caution. If you're in a non-taxing jurisdiction, such as one in the Middle East, an LLC can be a great vehicle because you don't have U.S. tax unless it's got effectively connected income in the U.S. and or owns U.S. situs assets like U.S. real estate, and it provides limited liability at the same time, and you don't have an estate tax issue to worry about necessarily. But I'd be cautious. Make sure that you thought through not just the U.S. side, but your home country side as well.
Excellent. I couldn't agree more. All right, Roger, you've still got more questions there?
Yeah, just one more, and it's would we like to comment on the use of French assurance vie? For those of you who aren't familiar with them, an assurance vie is a lot like a whole life policy. It has an investment component as well as a life insurance component. The life insurance component is really not a problem, although you know, depending on the size of it, you'll want to try and figure out where is this going to land. Is it going to land within your estate for estate tax purposes or not? And then the investment component is really where the problems arise, because more than likely the assurance fee is going to be invested in passive foreign investment companies, and whilst you are alive is going to be subject to fairly draconian reporting and taxation by US tax authorities. In general, I wouldn't recommend a US citizen invest in an assurance fee. If your spouse has an assurance fee and they are a non-resident, non-citizen, and you are the beneficiary of it, that's okay to a point, but you certainly don't want to inherit these PFICs and then become an owner of PFICs. You want to just receive cash. And that's the last of the previously emailed questions.
All right, great. Let's go to the questions that are being posed now live. And I'm going to skip right to a question posed by Leslie in France, because it is very similar to the question you just answered regarding assurance vie in France. Leslie writes, is a livret A good tool for American residents in France? And I'll answer that, Leslie. Yes, the livret A, this comes up fairly frequently. And of course, this underscores the problem when you are in a cross-border environment and you have a savings or investment product that is structured for tax efficiency in one country, but you are also taxable in another country. So it's structured for French tax purposes in this case, but you as an American are also taxable in the US, and the structuring has no meaning in the US. So a livret A, if you look at it from a US tax perspective, there's no special treatment of it under the US tax code. And then looking at it, what you're going to find is it has it's a trust structure, right? And its underlying investments are potentially PFICs, or not necessarily PFICs, but beneficial investments that don't have any particular tax benefit. So all of the good tax benefits that you would hope to accrue in a purely French context do not accrue for you in the US. And furthermore, you now create potentially punitive and complex tax reporting, such as reporting a foreign trust. So I would not use a livret A if I was also taxable in the US, although it might be good if I was only French and not taxable in the US. All right, and I'm gonna now jump back and talk through a question posed by Yoshiko, presumably in Spain. She writes, our principal interest, if you could address it, is the tax efficiency both in withdrawals from US-based retirement accounts, IRAs and 401ks as Spanish residents, and inheritance as a Spanish resident of US-based decedents' assets. Okay, very clear, Yoshiko. I'll answer this one. We've gone over this particular scenario many, many times in our practice here at Thun Financial Advisors. And the first one is very clear, as is the second one. As a US taxable person living in Spain and domiciled in Spain, you do have the protection of the US-Spanish double taxation treaty that will treat your IRAs and your 401ks as qualified, which means that you can expect that the IRA and 401k income will be deferred, and there will be no taxation of the underlying investments. But you will pay as you would have in the United States on the distribution. So in retirement, when you turn 72 and a half, if not before, and you have to start taking distributions from those US pension accounts, the full value of the distribution will be subject to Spanish income tax. Now, it will also be subject to US income tax if you are a US person, but you will then get a credit for having paid the tax first in Spain to offset what you owe in the US. Now, as a resident of Spain and you become an inheritee of a US-based estate, how is Spain going to treat this? Now, this has come up many, many times, as I said, and yes, Spain is one of those countries in Europe that will say, even though the asset, the decedent, and the assets of the decedent and the estate are outside of Spain, if the inheritee is a resident of Spain, it is subject to Spanish inheritance tax. And now what will you pay? Well, what you pay depends upon the region of Spain in which you live, and the rates can be quite high with very low exemptions in places like Andalusia and Barcelona, but they can be quite generous if you are in perhaps Madrid. And so that's the scenarios that you have to deal with as an American or as a US taxable person receiving an inheritance. If you're in Spain, you're Chico. So thank you very much for your questions. I'm going to go down to the next question, and I'm going to read it and ask Roger to answer. Michael writes, if a US expat citizen receives an investment account as a gift from a foreign national parent, is this still only reportable on 3520, yet have no tax implication?
Right. So from a U.S. perspective, you receive a gift, you report it on Form 3520 if it's over $100,000. Tax implications, well, that depends on what's in the account. If what you receive are, shares of Rolls-Royce or or LVMH or something like that, then that's fine. You've got an investment. But importantly, you have received that investment with the donor's basis. So whatever built-in capital gains are still there. And when you sell it, you'll get those capital gains. Now, you said a gift. If this was received as part of an inheritance, you would get a step up in that basis to the date of death. But if, on the other hand, this account contains passive foreign investment companies, then you're in a world of reporting problems, as well as potentially having significant built-in capital gains to deal with in the future. So it depends what's in the.
Excellent. Okay. Diana writes, American living in France, and I don't have natural children, but my second husband, now deceased, had 2 grown children with whom I am very close. I'd like to leave my estate to them, but I've heard that in France, the government takes about 50% unless you leave things to your spouse or children. Is there a way around that?
Yeah, so happily, you're in France. You can make an election in your French will to have U.S. estate succession laws apply, and then you can leave your assets to your second husband's children. You need to put this together with French notaire.
But Roger, that would get around the forced heirship issues or restructure it in your way. But is that going to affect the exemption amounts with respect to?
Yeah. She's still going to have to pay, or the recipients are still going to have to pay estate tax.
Right, as if they'd received from a third party, right?
Yeah, but it's not, and it can be significant, but it's not you're able to avoid the forced heirship issue of the state deciding who gets your assets.
Right, but it is going to be taxed more punitively than if those children were her natural children.
Correct. Yeah.
Okay, great. Thank you, Roger. Okay. Michael writes, how likely is it that the Biden administration will get rid of the step up in basis? You want to make a projection on that political question, Roger?
Not really. I mean, in many ways, the step up in basis defies reasonable logic. There's no tax paid, but there's a benefit. So I can certainly see the argument. One of the issues is that they might maintain the step up in basis, but they might impose a capital gains tax to go along with it, which is normally where you do get the step up. But how likely that is, I don't know.
Yeah, I think I might just guess here. There's going to be some negotiation around whether or not we get rid of the step up in basis or we reduce the exemption amounts, right? And getting rid of the step up in basis creates a lot of complexity that people are not prepared for, having historically not been subject, having had to have the step up in basis. So my personal guess is that the negotiations will revolve around keeping the step up in basis, but lowering substantially the exemption amounts. But I'm just, again, giving you my 2 cents, and there's many other people who have an opinion on this. But so we'll see. Completely could go in a lot of different ways, but I am sure that there will be some combination of a loss in step up in basis or a reduction of the exemption amounts over the next 5 to 6 years. All right, Maya writes, I'm a dual Italian-American citizen living in Italy with my Italian husband and my Italian children. I would like to start planning for my estate. I am 55. At the moment, I have some US investments, some investments in Italy, and I will be inheriting my parents' estate, investments and property and living trust, and a portion of another 2 trusts, not living trusts, but investment accounts set up by my aunt, to pass to some of us after our somewhat elderly cousin passes. What should I be doing now to make this easier? Okay, that's a really good question, and Roger, you want to start? It's fairly complex, but
yeah. So I think you want to try. I mean, presumably you still have time to have your parents' estate plan maybe reconsidered or modified slightly so that you're not inheriting trust interests, but you're actually going to inherit the assets themselves. So that would probably be a good move. And because you don't want to be trustee of a U.S. trust living in Italy. And again, it's a similar kind of question, I guess, with the aunt's accounts. Is how are you going to invest them? Are they trapped in irrevocable trusts, of which you are going to be some kind of a lifetime beneficiary, or are you actually going to receive the assets outright? I would look to put most of your assets in accounts that are in your own name, or joint with your spouse, or something like that, to start to make things easier. There are a lot of steps that I think would really happen during the administration of the estates that could make things simpler for you. But you want to make sure that the executors aren't precluded from taking such actions, that the estate plan's not overly prescriptive as to what the executor needs to do.
Yeah, I would just add to clarify, if properly structured, Italy is one of those countries that will not impose their own inheritance tax on assets received from a U.S. estate. However, once you introduce trusts and so forth, what should have passed tax-free can sometimes the consequence of the trust can result in it being taxed. Underscoring what Roger said, trying to receive the assets outside of the trust is probably an important scenario here. There's a lot of detail here that's not obvious to us from the question that we would have to go over, Maya, but I believe probably if you do this correctly, you can avoid completely Italian inheritance tax being imposed. But if it's not done correctly, you might find a lot of significant Italian complications that could have been avoided through good planning. All right, Kari writes, our children are dual citizens, US, UK, but the family home, their inheritance, is in the UK. I'm a US citizen, my husband is British. Our other investments are split US, UK, but US friendly investments for tax purposes, okay? Is there anything we need to consider specifically to address if our wills are written up under Scottish law? Roger, while I think about that one, I'll let you answer it.
Yeah, I mean, I don't so essentially this is going to be a UK estate subject to UK estate or inheritance, as they like to call it, tax. So everything over 325,000 pounds plus on the family home, another 175,000, I think it is going to pass estate tax free, but everything after that then is going to be or inheritance tax free. Everything after that's going to be subject to inheritance tax. So I really see, looking at possible ways of reducing your estate for UK inheritance tax as being the main focus. You say US friendly, I'm assuming it's also UK friendly because there's a bit of an overlap there between the two regimes, but you want to make sure you've got US and UK friendly investments. But I don't, nothing particularly jumps out at me that would cause me sort of special concern.
Yeah, all the normal UK strategies would apply here, right?
Yeah.
Have your primary residence exempted, have assets in pension accounts which are also exempted, and so forth. Yeah, so I don't think basically the question is, what is the UK complication in this scenario? And I don't think the US citizenship really raises any particular complication other than the normal UK issues.
Yeah, and if your estate is big enough to be subject to US estate tax, you're already going to be paying bucket loads of UK inheritance tax.
In which case, the credit will offset what is owed in the US in any case.
Yeah, you'll have no net new tax because of that.
All right, great. All right, Mark writes, I have a UK national client who set up a UK discretionary trust with a UK investment asset held within a trust. There are a total of 8 beneficiaries, grandchildren, 2 of which are US-UK dual nationals living in the US. What are the tax implications on the payment from the trust going to the US-UK grandchildren for both the trustees and beneficiaries? Okay, so you've got 2 US nationals inheriting from a US trust. So these are beneficiaries of a foreign trust to begin with.
Right, from a UK trust, yeah. Yeah, so you're going to have to go over the foreign, probably at this point, non-grantor trust rules. There's definitely maybe even current disclosure requirements. And then the big thing you're really going to have to watch with this UK trust is periodic charges to inheritance tax. If you need good US UK tax counsel, send us an email. This could be quite a set of liabilities.
Right. So there could be liabilities arising currently for the US beneficiaries. Isn't that correct, Roger?
Yeah.
Yeah. So this is one of those scenarios where we have seen quite a few cases of people having absolutely no idea that they were subject to US taxation when they were, and it goes on for many, many years until the estate is resolved, and lo and behold, the IRS says, well, you were the beneficiary of this trust all these years. You needed to be paying, or the trust needed to be paying on your behalf, right? And so that arises when you have US taxable persons who are beneficiaries of foreign trusts. This is a real landmine, Mark, so I would make sure that your clients are getting this reviewed by an expert US-UK tax advisor, and making sure that whatever taxes may potentially be due now to those US persons are being paid properly. All right. All right, let's go down to Shirley. Shirley writes, I'm an American living in Japan. My husband is a Japanese national. We have no children. I have named my husband as the beneficiary on my traditional IRA, Roth IRA, and 403b accounts. What are the tax implications for us?
So from a U.S. perspective, I don't really see any particular issues. You know, when he takes money out of those accounts, they will be subject to income tax. So that doesn't really change anything. For Japan, David?
Good question. I'm trying to remember now. So the question here is there an unlimited exemption between spouses in Japan? And I believe that the answer is no. There is a tax imposed between spouses with relatively high exemptions. So you may be facing, Shirley, a Japanese inheritance tax on the value of those IRAs. Even though under US law, all of those US retirement accounts could pass tax-free to your well, they are subject to so you're leaving them to your you don't have an unlimited spousal exemption in the US, but you have an $11.7 million exemption. So presuming the asset values, even the IRAs and so forth, are less than that, you would not have a US estate tax. But the question here is, because Japan does not have an unlimited exemption itself, and the exemption amounts are lower, you are probably facing a Japanese inheritance tax upon the inheritance by your husband of those assets. So I think that's where you have to focus here. Unless your estate is worth more than $11.7 million, you're going to have to focus on the Japanese inheritance tax, which can be quite punitive. And the exemptions amount in Japan are really quite low compared to the US or even in Europe. All right, Michael writes, if a US citizen resident of an EU country leaves his assets to an EU citizen, does this have US inheritance tax implications? All right, so a US citizen residing in an EU country leaves his assets to an EU citizen. Does this have US inheritance tax implications?
So again, as long as you're within the 11.7 million, you're not going to have US estate tax implications. You may well have inheritance tax implications in the EU country. A lot of the EU countries have inheritance tax, which was borne by the recipient. Beyond that, I think that's
right. So one thing to point out here is the citizenship, right? So the US citizenship is always critical. As long as you are a US citizen, yes, you do have to address whether or not there is a US estate tax due on the estate, right? And that doesn't go away because you happen to reside in the EU or because your beneficiaries are EU citizens, right? The citizenship of the beneficiary really has no implications. Now, the residency of the recipient does have implications because that will determine whether or not there might be a treaty provision here that could come into play. But in general, citizenship outside of the citizenship of the US citizen, which makes it subject to potentially to US estate tax, is irrelevant. It's the residency, the country of residency that's important here. And in the EU, the US has different treaties with different countries within the EU. And so this could have some impact. And then the country of residence own rules are probably the most pertinent issue here, right? So for example, a inheritee in Germany of a US estate will pay German inheritance tax the same in Spain, but in the UK or in the Netherlands, generally you would not tax an inheritance received from a US decedent. So it's a lot of different issues here. The country of residence, the rules in those countries, where the assets are situated, and so on and so forth, Michael. All right, Roger, Chris writes, how should a UK resident US citizen save for retirement estate given the $60,000 limit of exemption? Thinking of my, for my daughter on the estate. Okay, great example of the confusion that we have about this $60,000 exemption limit. Can you just clarify this?
Yeah, sure. So the limit applies to non-US domiciliaries. If you're a US citizen, even if you might now be a UK domiciliary, you still get the 11.7 million unified exemption amount. So not the $60,000. So if you're a US citizen resident in the UK, your first 11.7 million is not going to be subject to US estate tax. But your estate may be subject to UK inheritance tax once it's over £325,000. But the $60,000 limit isn't your problem. Most likely the UK inheritance tax threshold would be the issue that you need to deal with. So no, I guess no particular restrictions on how you would save for retirement. As a US citizen, you want to not invest in PFICs. As a UK resident, you want to invest in UK reporting funds. And we'd be happy to help.
All right, great. Thank you, Roger. All right, moving on. Stephen writes, does the creation of a will in a US state expose one to the state's inheritance tax, assuming the state in question has an inheritance tax? Can any state be used to establish a will even if you do not have a connection history with the state in question? Good and important question. Roger, go ahead.
So I would say that's very much state dependent. Certainly having a will under the laws of an individual state may be a fairly strong indicator that you intend to return to the state, that you intend to remain domiciled there, you intend to be subject to whatever estate or inheritance tax rules that may apply to you. But again, often inheritance taxes relate to the recipient of the bequest, not the donor. Now, again, can you use a state to establish a will? I think that's also state dependent. I think that New York is probably very likely to allow you to use their probate system, but you would need some kind of connection. But that connection could be as tenuous as you own, U.S. securities, many of which are traded in New York. But certainly, if you owned a piece of real estate, or if you previously lived there, or something like that, that would give you very strong ties. But it's not, it's a conflict of laws issue, often with your other jurisdiction, as to whether a particular state would take control of the probate process for your estate. But as we've mentioned a few times, if you live in a state with an estate tax treaty, or if you live in a state with a that allows you to use that EU regulation, you may be able to elect those laws without actually having a will under those laws.
Exactly. And of course, none of this issue of what jurisdiction might apply or could be applied in the US will exempt you from the laws in your own country, right? If you live in Europe, those rules will prevail, and they will be recognized as prevailing if you die as a domicile. They will be recognized by US courts. For example, if you die in Europe and you're domiciled that country, and it is challenged, right? The probate and the resolution of the estate could easily be moved back to Europe, for example, and you could be subject to all of the EU rules, both with respect to the rules of succession and the estate tax and inheritance tax implications, even if you've tried to set it up in the United States to avoid that. So this is an area fraught with potential litigation risk when you are trying to create, for example, a U.S. will to pass U.S. assets, even though you're a domicile of some other country. Right. Okay, moving on here. Michael writes, if a U.S. citizen resident of Austria, which has a treaty with the U.S., leaves his assets to a citizen of the Netherlands, which does not have a treaty with the U.S., does this have U.S. estate tax implications? Well, first of all, I think Austria, both Austria and the Netherlands have estate tax treaties with the U.S. But Roger, do you want to try to answer this one?
Yeah. So I mean, yeah, they both have treaties, but it's really going to be a question of the U.S. From a U.S. estate tax perspective, are you over the threshold? If not, then there's no estate tax implications. Do you assume you have some of the exemption amounts left? And then it's going to be a matter of, well, you're a resident of Austria as well. So does Austria want to tax? What does the treaty say there? And then you've got someone in the Netherlands receiving assets. And so that's probably not going to care very much about, the fact that you're a U.S. citizen, although it may. It'll also take into account the fact you're an Austrian resident. So you've got 3 countries and potentially 3 estate tax treaties to coordinate. But U.S. estate tax, not unless you're over the 11.7 million. Or whatever the future threshold happens to be.
Excellent, thank you. All right, Elizabeth writes, dual U.S. French citizens with property in both countries and grown children and grandchildren in the U.S. and the U.K. Now, the critical information, Elizabeth, that you didn't provide for me is you didn't tell us where you reside. You say you're U.S. and French citizens, but you didn't tell me if you live in the U.S. or you live in France. Makes it very, very difficult to answer this question. I will quickly say, if you are, and usually residency, aside from U.S. citizenship, is the key question, right? So if, Elizabeth, you live in France and you die domiciliary there, you're going to have to deal with French inheritance tax on the assets you leave to your children wherever they are. If you're in the U.S., if you reside in the U.S., right, your assets, because of your French citizen, will not be subject to French inheritance tax, except those assets that are French situs assets, such as French real estate. So without more details, it's very hard to give you a much more detailed answer than that, Elizabeth. All right, Fred writes, and I think you already answered this question from Fred, so I'm going to skip right over this one, and I'm going to move on to the question from Bradley, who writes, he had, if your non-resident alien spouse is a dual citizen, you live in the Netherlands with spouse, you leave everything to spouse.
So probably no U.S. estate tax, and you're just, it would probably be exactly the same as anyone in the Netherlands leaving assets to their spouse in the Netherlands.
Yeah, unfortunately, Bradley, it's not very clear what the question is here, so give us a call on that one. Okay, Charlone writes, I joined late. Is there a recording I can watch? Yes, you having been on this will get a email with a replay, Charlone. So you can watch it there. All right, Roberto writes, are there any particular tough issues for US citizens living in Switzerland with virtually all of our assets in the US and our children in the US as well? All right, I'll take that one. I've worked with a lot of clients in Switzerland over the years. All right, so Switzerland has, of course, a system of cantonal taxes, and some cantons have inheritance tax and some don't. So without knowing specifically which canton you live in, Roberto, we're a little bit limited in the answer, but that will be a critical question. What is the inheritance tax that your assets would be subject to at the cantonal level? Aside from that, of course, you are also subject to the U.S. estate tax. And so currently with an $11.7 million exemption, that would not apply between you and your spouse because you're both U.S. citizens, as I understand, but that is the exemption amount that you have to work with from the U.S. side when passing your assets to your children. The situs of the assets is not particularly important here because they're all subject to the U.S. laws, and Switzerland would also, to the extent that they impose their own inheritance tax, would apply to your worldwide assets as well. So the fact that those are in the U.S. is not going to make them exempt from any applicable Swiss inheritance tax. Anything I'm missing there, Roger?
No, I mean, assuming you own all of these assets in your own name, and you don't have it in some complex trust structures or something like that, which would further complicate matters for you. That would be it. And again, estate rules are cantonal in nature, so there's not one simple rule for Switzerland.
Right. Okay. All right. Michael writes, so could U.S. citizen resident EU country convert their U.S. securities to cash the day before their death and then only be liable for an amount larger than 11.7 million USD? I think this goes back to Michael's earlier question, where he may have been confused about the applicability of the $60,000 exemption. Right, so Michael, it doesn't make a difference. The $11.7 million exemption that you have for the U.S. applies whether the money is cash or, so I think what you're thinking here is cash is not considered a U.S. situs asset, but you still, as a U.S. citizen, work within that $11.7 million for U.S. estate tax purposes, whether or not the assets are cash or securities or any other type of asset. All right, here's a question from Suraj. What is the tax treatment for U.S. beneficiaries of a DIFC foundation created in Dubai International Financial Center? All right, Roger, you've got a lot of experience in Dubai.
So this is going to be a foreign trust. From a U.S. perspective, it's going to look like a trust and it's going to be foreign. So you're going to have immediate reporting requirements possibly for the beneficiaries and for the settlor if they were also, or the founder if they were also a U.S. taxpayer. And beyond that, income tax liability based on the assets that are distributed from the trust, and the trust itself having an income tax liability for undistributed assets, undistributed income. So overall, probably not a very good U.S. tax result for a foreign trust.
All right, great. Roger, we've been answering questions now for 50 minutes and we've gotten through approximately 1/3 of the questions. So we're going to accelerate the process here. We're going to answer all the questions, but we're going to cut to the key issues that the questioner is raising and move on to the next one in a relatively expedited manner. And with that in mind, Jennifer writes, my elderly parents have provided for my children via a trust, I believe. The kids are dual US-French citizens and reside currently in France. What do I need to check in regards to the setup of this eventual inheritance?
So they're likely to be subject to inheritance tax in France from a third party, namely the trust. So they'll get the worst possible allowances.
Right, but I think based upon previous experience, because France does not otherwise tax inheritances from abroad, you can take some action here, a good lawyer, to make sure that there is, even though you're inheriting from a trust, which could raise the problem that Roger underscores here, you can get around that, and you can get around it in a way that even though the assets were in a trust in the U.S., a beneficiary in France inheriting is not going to have to pay French inheritance tax. So I've seen that in a couple of cases now. So Jennifer, I would get in touch with a good lawyer in France, and if you need help there, give us a call and we can put you in touch with them. All right. Ann writes, what if you elect to have U.S. state law apply to your inheritance and you also have land or assets in France? Can you use each country's laws for each country's assets? Roger?
Well, sort of. I mean, if you're, a big question here is where are you resident? I mean, if you're resident in France, then you can elect your U.S. state succession laws to apply to your entire estate, including the assets in France. If you don't want to do that, you can have French succession law apply to everything. You can probably also make a sort of sub-election to have U.S. state succession law apply just to your U.S. assets. But that's not going to have any effect on any tax liabilities you might have. So, countries' laws is which kinds of laws are you looking at? Those elections have no effect on tax liabilities.
Right. Okay, Anthony writes, and I'll take this one. Can a U.S. citizen inherit from an NRA, that is non-resident alien parent, without U.S. estate taxes? So, Anthony, the answer to this is very clear. The U.S. does not have an inheritance tax, so the tax is never imposed on the inheritee, right? So, you inheriting from your non-resident alien parent would pay no tax. Now, the question is your non-resident alien subject to U.S. estate tax? Is the estate that your non-resident alien parent has, are their assets subject to U.S. estate tax that they would have to pay before passing the assets on to you, the beneficiary, the inheritee? And the question is, non-resident aliens would only potentially be subject to U.S. estate tax on U.S. situs assets, right? So if your parents own U.S. situs assets, they do potentially have a U.S. estate tax liability that is going to have to be paid when they pass. Now, depending upon what country they live in, there may be a treaty that exempts them from this U.S. estate tax. But that would be the critical issue here. But you do not owe anything on gifts from non-resident alien parents or parents outside the United States who are themselves otherwise not subject to estate tax because they own U.S. situs assets. All right, Henry writes, I live in the UK and am moving to Greece where I own property. Most of my financial assets are in the US and the UK. From an estate planning perspective, since the US succession laws don't apply there, does it make sense to set up a will once I get to Greece?
Yeah, so in general, the answer is going to be, it makes sense to have a will where you are living and intend to remain. And So yes, I would get a new will when you get to Greece, and if you've left assets in the US and the UK, I would talk to counsel that understands the implications of wanting to probate those assets as well.
All right. Tanya writes, moved to UK, all of assets, equities in US, best option to reduce estate taxes. Well, Tanya, that's not a lot of information, but I'll tell you the very simple answer here is for probably for you, it's simply to focus on the UK inheritance tax laws, because if you become a domicile of the UK and are domiciled there at death, and we won't go into all the rules in the UK about when you become a domicile, but presuming you're a domicile at death in the UK, all of your assets, including all of your US investment accounts and your stocks, will be subject to UK inheritance tax, IHT. And therefore, there are a variety of techniques that are used in the UK to mitigate that, but that's going to be your primary tax. Once you've paid the UK tax and you're also dealing with your $11.7 million exemption in the US, you will probably almost certainly not have any US tax, estate tax liability. All right, Roger, next question comes from Julie. Does the $11.7 million exemption apply to married US citizens who are non-residents? If it becomes a $60,000 exemption for citizens outside the US, what is the best possible vehicle to protect?
Right.
Roger,
yeah, so the exemption applies to citizens. For married US citizens, not only do you both have the exemption, but the exemption is portable. So any that isn't used on the death of the first can be used on the death of the second. So you've got a, what is it, $23 million exemption between you for your estate. The $60,000 exemption is for non-resident, non-citizens, non-domiciliaries. If there are changes to US estate tax exemptions, the numbers going around, well, the automatic number that's kind of going to happen if nothing else happens is it'll go back to about 6 million. The kind of next number that's bandied around is 3.5 million. And again, we think portability is likely to stay in any case, because it just seems fair that if you don't use all your exemption, your spouse could use it. That wouldn't be a concern. If you're likely to be over 3.5 or 7 million, there are things you can do, but they generally involve giving your assets away whilst you're alive. So that may or may not be something you want to do.
Right, I just want to underscore here, because I'm not sure if Julie's asking this, but I want to make it perfectly clear, Julie. If you are both US citizen spouses, you have an unlimited exemption between you, right? So the $11.7 million or whatever it may be reduced to does not apply between the spouses, as long as you are both US citizens. So we want to be very clear about that. All right, Julie writes, how can we register for upcoming webinars? Well, just go to our website and we always have an announcement there of upcoming webinars and you can register for them right there. Get on our mailing list too, and then you will get notifications of upcoming webinars. All right, Anthony writes, do you know if Austria currently has an estate tax treaty? Well, I've actually got the up right here, and you can see right here on the screen that Austria does have a estate tax treaty with the US. All right, moving on. Rajana writes, what is the estate tax planning solution for US citizen now living permanently in India? US trust, Indian trust? Roger, you want to try India? No estate tax treaty with India.
Yeah, without an estate tax treaty, I'm not sure if I would head into the world of trusts, because you have no idea how things are going to be treated. As a citizen, you're still subject to US estate taxes, even though you live permanently in India. You are also likely to subject to any transfer taxes in India.
But India doesn't have an inheritance tax, or an estate tax.
So then you're going to be subject to US estate tax. on your worldwide estate. You know, putting it into a trust, you know, unless you are making an irrevocable gift, isn't going to change your U.S. estate tax liability. And if you are making a gift, you need to figure out how much of your current exemption you want to use. Some people are making significant gifts to use the exemption on the basis that it's going to go away or be dramatically reduced. So that might be a planning opportunity you want to look at.
Great. Okay, Sylvain writes, how do those taxes and exemptions change when a spouse has double nationality, e.g. US and French? All right, so Sylvain, well, how do they change? So let me tell you this. So in France, right, where we have many clients that have been over this for many years now, the US-French double taxation treaty creates a very beneficial outcome for Americans in France with respect to US sourced income not being subject to French taxation, right? You can exempt US sourced income from income tax in France. And that is we talk a lot about this. It makes France a really wonderful place to retire when you retire with US sourced income. But it does not affect the French estate tax liabilities, right? That is not exempted. And so if you are in France, and even if you are a US citizen, you have to deal completely with the French estate tax, or really an inheritance tax that will be imposed on your worldwide assets at the time of your death, even assets outside of France. And so, and those rates in France are quite punitive. And so while we often say that France is a great country for tax purposes for Americans to live during their retirement, it's not such a great place to die. So I hope that helps. All right, moving on. Kristen writes, I am in the UK, retired here. I have no children, but want to divide my estate between 6 nieces and nephews, some US citizens in the US, some UK citizens in the UK. I have US investments in cash and a house and investments in the UK. Do I need an executor in both countries? Good question.
I would say probably not. I would think you would get a UK executor and they would be able to handle your US investments.
Exactly, I agree. All right, Ann writes, you mentioned non-resident, non-citizen, but what about non-resident citizens? E.g., what are the options for a US citizen domiciled in an EU country with holdings in both countries, leaving to beneficiary who has dual citizenship?
So you're going to be subject to both countries' laws. Your domicile, the fact you're a non-resident doesn't really matter as long as you're a US citizen. Your worldwide estate is going to be subject to US estate tax. And then because you are a resident in an EU country, again, depending on the treaty, will depend on how you're treated, but you're going to be subject to their inheritance tax laws as well. And if your beneficiary is also resident in one of those EU countries, they may be subject to the inheritance tax laws of that country, even if it's a totally different country from the one you live in. So you really need to look at, what's applying. You know what's applying to you as a U.S. citizen from the U.S. estate tax laws, but what are the country's inheritance and succession laws, where the beneficiaries are.
Right, and each country in the EU has different rules and different laws, right? So saying EU citizen really doesn't give us much in terms of understanding what the potential inheritance tax is there. Anne. All right, Diana writes, I live in the UK and married to a UK citizen. I have recently changed our jointly held property to now be only in my husband's name through the UK land registry. Does this constitute gifting my share of the house to my husband, which I will need to report on my tax return? The 50% share I moved to his name did exceed the $159,000 gift tax exemption, so will I be liable to pay taxes on the excess? Also, if we sell the house, will I now be liable for any capital gains as the property is no longer legally owned by me? Great question, Diana. I think Roger can answer this one.
So the first thing you have to do with your gift is report it on a gift tax return. And you will likely want to use some of your lifetime exemption, so some of that 11.7 million, as opposed to paying gift tax. Of course, that's your option. As you no longer own the house, you won't be liable for capital gains tax when it's sold. And this is a device that's sometimes used where there is a non-resident, non-citizen married to a U.S. citizen, and that's the gift of appreciated assets to the non-resident, non-citizen, who then sells them free of U.S. capital gains tax. But you have to be careful that you're not just doing that and then giving the money back, because that will undo the transaction entirely. But in this scenario, it sounds like you're taking all the right steps, but you do need to file that gift tax return.
Right. Okay, all right. And next question comes from Terry. I have a sizable 403B account in the US. Are these trusts for the purposes of estate planning? Will they be once they're rolled into IRAs? My wife and I are both citizens of both the US and Canada. We have lived in Canada for several decades, have no other property in the US, and will not plan on returning to the US. Okay, so the real issue here is, how is Canada? So these are trusts generally. US retirement accounts are technically trusts, but there is a treaty between the US and Canada that qualifies those pension schemes to be treated as they would be in Canada. So the question is, we are always in a gray area here when advising on the rolling over of US retirement accounts to beneficiaries. There is now the inherited IRA principle. There was always the ability of spouses to inherit IRAs. So I think you can expect that you can pass the assets to your spouse in Canada without any tax being imposed. Eventually, when the money comes out of these 403Bs, Canada will tax it as income, right, Roger? So that's the real issue here. And if this is just between you and your spouse, and you're not looking at, there's no children, right? I think was what I read. So the other question, the only question here that I would be concerned about trying to get clarification on is, could you pass these assets tax-free in the form of an inherited IRA to non-citizen beneficiaries such as your children without it being taxable at that moment, or not? And I think that's probably a technical Canadian question, probably has not been resolved. Roger?
Yeah, so I mean, I think the real issue you're looking at is on the second to die, you'll get a capital gains tax in Canada on whatever's in the accounts.
Right. Yeah, so it's a capital gains, not an income tax issue.
Yeah, well, I mean, within retirement accounts, it could just be an income tax issue on those accounts. Yeah, if they're going to be taken out over a period of time by Canadian residents.
Right. Okay, right. All right. Marilyn writes, I'm 72, widowed, and living in the UK. My beneficiaries are stepdaughters, their children in the UK, and brother, nieces and nephews living in the US. I have property and investments in the UK, but also investments with Schwab in the US. What are my best options, please? Roger?
I mean, this is really going to boil down to being a UK inheritance tax issue. You can start gifting if you want, and if you survive the gift by and doing so using up some of your US estate tax exemption. And then in the UK, there's a thing called taper relief, which means that the amount of inheritance tax payable is reduced for pretty much for every year that you survive a gift. And if you survive a gift by 7 years, there's no inheritance tax payable on that gift. It's not brought back into your estate. So if you're ready to start making gifts, that would reduce your UK your liability for UK inheritance tax, and it reduces a little bit, after just a few years of surviving the gift. So that might be a strategy to follow. And your US side, you need to file gift tax returns for any gift that's over $15,000 per recipient. So you give away $15,000 to every child and nephew and niece and stepchild without any returns, but that may not make much of a dent in your UK inheritance tax liability.
Right. Okay, great. Next question from Anthony. Anthony writes, can you say anything about the new situs rule for Austria? I think Anthony's probably looking at the table I have up on the screen right now, and you'll notice that the asterisk on the gift and estate tax treaties cites new situs rules. What are new situs rules? Okay, in U.S. estate tax treaties, they can be broadly divided between treaties that have new situs and old situs rules. New situs rules simply state that a resident of that country, which would include Austria, which is a new situs country, the U.S.-Austria estate tax treaty gives an Austrian resident basically no assets that are in the U.S. will be treated as U.S. situs assets for the purposes of the U.S. estate tax treaty that is imposed on non-resident aliens, right? So that's $60,000 exemption.
Except for real estate and business assets.
Yes, except for real estate, right? So if you have a securities, right? So if you have a securities portfolio, right, it all, no matter what its size is, will be exempt from U.S. estate tax. In the old situs rule treaties, there's a formula that determines a percentage of the current U.S. estate tax exemption that would apply in that case. All right, I hope that helps, Anthony. Are U.S. trusts recognized in Austria? Very briefly, I would say generally no, or not only no, they're not going to be recognized, but they may be even perniciously recognized. They may be recognized as third parties, right? And you may forego the benefit in Austria of leaving assets to direct heirs, and generally there is not an inheritance tax in Austria, but if you use a trust, you may find out you now do have an inheritance tax. So be very careful with using U.S. trusts in Austria. All right. C writes, should we simplify by undoing our living trust in California? How does one go about doing that, given we live in Switzerland? All right, I'll address that one, C. Switzerland is a country that is actually pretty liberal in terms of recognizing other countries' what we often call a will substitute, such as a trust structure. So they will not necessarily treat punitively a U.S. trust per se, as long as it doesn't contradict any local Swiss law that applies. And of course, it has no impact on taxation. So it's not going to exempt you from Swiss, for example, inheritance or gift tax that might otherwise apply depending upon the canton you're in. So then the question is, are you simplifying? So then the question is, does that trust do anything for you in California? Well, it is true that when we're talking about probate of an asset, the laws of the country with respect to real estate that apply will be the country where that situs asset exists. So it is possible, it seems to me, that keeping your California trust could expedite the probate of a house that you have, a living trust. Oh yeah, so I would say basically it could only apply if you're housing real estate in that trust, but other types of assets, if that's all you have, I'd get rid of it. I don't know. Roger, you want to expand on that or comment?
Yeah. I mean, unless you're using it to hold California real estate, I'd get rid of it. And so how do you do it? Well, from a California perspective, you just take the assets back because it's taxably it's you. Transfer the assets back to yourself. You'd want to be careful and check with Swiss counsel on any changes that you make, and also any issues that you may already have by having the trust. And again, that'll be at a cantonal level, so it depends where you are.
Yeah. All right. Great. All right. Cheryl writes, hello. I am a U.S. citizen who has lived in Germany for over 30 years. I plan to inherit to my non-U.S. citizen husband and my niece, who is a U.S. citizen living in U.S. Okay. Can I use TOD on my investment accounts without anyone having to pay inheritance tax? Okay, so she's a U.S. citizen living in Germany. That's really all we have to know here.
Yeah, so the answer is no.
Do not use TOD if you are domiciled at death in Germany. Your assets your worldwide assets, even all of your U.S. assets, are subject to German rules, and Germany will not recognize the principle of TOD. All right, let's move on here. All right. Jennifer writes, if living in the U.S. and domiciled in the U.S. upon death, then would any property, pensions, real estate, property in the UK be subject to UK inheritance tax?
So yes. I mean, you want to double check the treaty, but in general, UK real estate is going to be subject to UK inheritance tax. Your pension, possibly not. I'd want to check that before being definitive on it.
Right. Okay. Patricia writes, I have become a Spanish citizen, which requires me to renounce my U.S. citizenship. However, the U.S. does not recognize that I have renounced my U.S. citizenship to the Spanish government. I have a Schwab brokerage account in the U.S. managed by Thun. From what you have said, I am assuming that my brokerage assets in the U.S. will be subject to Spanish inheritance tax, given that I live in Spain and I plan on staying here until I die. That is absolutely correct. Patricia, your assets will be subject to Spanish inheritance tax upon your death. That's very clear. If you are domiciled of Spain at that time. The question of citizenship really doesn't even matter in that scenario. All right, next question. Stephen writes, are you aware of any countries that have challenged the decedent's place of domicile? Example, a decedent splits time between two countries, say 55% of the year in the US, 45% of the year in another country X. Are these cases where country X attempts to apply their tax regime based upon a part-time domicile? Good question, Stephen. No, look, I've never heard of a part-time domicile. You are either a resident and a domicile. I mean, if you're talking about most places in Europe, if you are there for 183 days of 365, you are resident, and in most countries in Europe, the UK exempted, there's no distinction between resident and domicile. So once you've been there and you've triggered that 183 days, your total worldwide estate will be subject to the local inheritance tax. It's not really a question of, how much time did I happen to spend in the other country or what that other country was. They will apply their own rule as to whether or not you are a domicile and based upon how much time you've been in their country. I know that's the case in Germany, for example, where we have worked with a couple of clients who unfortunately moved to Germany, had been there only for a very short time, but critically more than 183 days, and had a parent in the US pass away, and suddenly that whole US inheritance is now fully subject to German inheritance tax. It didn't matter whether or not that person intended to leave or they were just there on an extended stay. You were in Germany for 183 days. You are a domicile and a resident of Germany, and you will pay German inheritance tax. Now, if you die as an American in Germany, there is a 10-year exemption in the German U.S.-German estate tax treaty that could affect your U.S. assets, but that's another issue. Roger, anything you want to add to that one?
No, yeah, I mean, the point is, it's not a splitting issue. If you can be domiciled, you can be considered your state can be taxable in more than one country. If you're a U.S. citizen domiciled in the UK, you're subject to, well, with the benefit of the treaty, you're subject to the laws of both countries. So that, it's not a part-time residency type of treatment.
Right. All right. Spencer writes, just as many American advisors do not understand cross-border estate planning issues, the same is true of advisors here in the Netherlands. Do you have a database of country-specific estate planning advisors versed in both the laws of our residents and the U.S.? Yes, we do, Spencer. And we can put you in touch with lawyers who do understand both countries. All right, moving on. Thank you for the webinar. I found it very informative. You're welcome, Robert. Kim writes, if I move to Switzerland, will my trust be recognized? My beneficiary is a dual national U.S.-Swiss citizen living in Switzerland. Would it make tax sense to remain living in the U.S.? Okay, Kim, I kind of addressed this earlier. Switzerland's very liberal with respect to trust, so your U.S. trust is not necessarily going to create any problems in Switzerland as long as it doesn't violate any Swiss rule that would prevail otherwise. So it's not mandatory, it's not automatic that it creates a problem in Switzerland. The question you've got to ask is, what goal is, what function is it achieving? It may not achieve the function that it originally had once you're outside of the U.S. Would it make tax sense to remain living in the U.S.? If so, you're asking if I move to Switzerland, would it make tax sense to live in the U.S.? Well, that's a tough question, right? There are pros and cons tax-wise to moving to Switzerland. Most people don't make decisions ultimately about whether they're going to live in the U.S. or Switzerland based upon taxes. Ultimately, actually, in those countries, the tax rates end up being pretty similar, so you're not going to necessarily pay a ton more tax if you move to Switzerland. But it depends upon the canton you go to. It depends upon the nature of your assets and other factors. All right, so there you go, Kim. All right, Carnetta writes, Roger, for you. My daughter is domiciled in Switzerland, but has citizenship in the US, France, and Switzerland. When she turns 18, she would like to invest her savings in US stocks and US mutual funds. What investment strategy do you advise for long-term growth with the least global tax liabilities? Is contributing to a Roth IRA a good idea?
So she's Swiss resident. Well, okay, so the first one is, yeah, long-term growth, broadly diversified portfolios using low-cost US ETFs for this US citizen. Roth contributions, well, that depends on where you're going to be when you want to take the money out as to whether or not they're going to be, the tax-free nature of the distribution is going to be recognized. The issue as well with contributing to IRAs in any case is a limit on the ability to contribute based on having any earned income that's not already been excluded, as well as even if you have that, you still have a limit. So if you wanted to save $10,000 a year, you couldn't do it into a Roth IRA, even using something like a backdoor contribution. So in general, I would suggest that for someone turning 18 to open their own brokerage account in the US, buy US ETFs in a broadly diversified manner, and pay the capital gains and dividend taxes on capital gains and dividends if and when they arise, and hold it for the long term. Certainly, time is on your side there.
Right. And yes, so I think the key for an 18-year-old, she's going to have awfully high income for her to be eligible to contribute to an IRA in the U.S., as Roger underscored. Furthermore, Roth IRAs are not recognized as pension accounts in Switzerland. A regular traditional IRA would be under the terms of the US-UK, US-Swiss double taxation treaty, but that recognition does not accrue in the case of a Roth IRA. So Roths are no-go in Switzerland. All right, next question comes from Vidya. Writes, if you are a US citizen domiciled in France, can you still be one of the executors of your parents' US trust and at some point receive distributions? What are the worldwide tax implications? Conversely, if I have property in France, how do I pass that on to the family in the US upon death? Roger?
So part two, a French will would allow you to do that. That you can, as a U.S. citizen, you can pick your state and use that succession election. For the trust, all right. So there's a bit of a terminology issue here. So if you're the executor of their estate, that's one set of facts, and you'd be expected to kind of wrap up the estate. You'd want to be careful that the estate itself didn't become French resident. If you're trustee of a US trust, you may have just made that a foreign trust from a US perspective, causing sort of fairly negative tax implications to any of the US beneficiaries and making the trust itself taxable perhaps in France. So it wouldn't be on my recommended list of things to do. So then you ask worldwide tax implications. As I say, you may well trigger additional reporting and taxes in the US as well as in France.
Right. Excellent. Thank you. All right. Anthony writes, I am a U.S. citizen living in Austria. My NRA spouse and I have a New York State will and some assets in New York State. My main connection now, however, is to a close family member living in South Carolina. Would you recommend that my spouse and I create new wills and also a trust in South Carolina? No, I wouldn't, Anthony. What you're implying is that you're going to try to execute a probate of your estate under US law. But if you are living in Austria, that is a very risky maneuver, because what you're effectively trying to do is skirt the Austrian laws that would apply, given the fact that you are a domicile of Austria. And so I would not take that route. I would set up your affairs using an Austrian trust, an Austrian will, and make sure that your assets are going to be probated, except for perhaps real estate in the US, are otherwise going to be probated according to the laws of Austria. Roger, anything you would want to add there?
No, that's fine. I mean, I think you could make that EU election to use the laws of New York to devolve your assets, but
Good point.
That depends on whether you want to, whether the Austrian succession rules work for you or not.
Right, but even if you use EU 650/2012, you do that through your Austrian will.
Your Austrian will, yeah, absolutely. Yeah.
All right, Anna writes, hi Roger, thank you for the webinar. Could you please comment on being a dual UK-US citizen living in Britain that is the beneficiary of a US revocable living trust? Can you please comment on the implications of being the trustee administrator as a dual US-UK citizen and beneficiary of the trust after the US settlers are deceased? For this instance, you can assume the assets are below US estate tax, are below the US estate tax threshold.
Right. So you're probably fine at the beginning, where there's a US revocable living trust of which you are the beneficiary, or a potential future beneficiary. I wouldn't have any particular concern there. But on the death of the settlors, if you then become the trustee, you are now making it a UK trust administered out of the UK under what's in the UK is considered mind and management rules. So then it becomes a UK trust for UK income tax purposes. And I think the exemption on a UK trust is $1,000, and beyond that, then you're into paying UK income tax at a trust level. Now, if you're the only beneficiary, you would definitely want to get out of this because you could then have personal exemptions, etc., to apply. If there are other beneficiaries, I would say that your staying on as trustee is to their detriment, and that could cause you lots of problems. So I wouldn't want to do that either. Ideally, you'll just get your share out of the trust and leave someone else as the continuing trustee.
All right, good. Thank you, Roger. All right, Shahrukh writes, what is your feeling on multiple wills, one in each jurisdiction covering the assets of that jurisdiction, to avoid the complications of cross-border probate? U.S. citizen residing in Argentina in this case, but it is a general question as well. All right, Shahrukh, let me answer that one. In general, our rule of thumb is to avoid multiple wills at all costs. They can conflict. They can create the potential for litigation where they are applied. One will should the best solution in almost all cases is to use one will that gives specific instructions to probate all assets according to the jurisdictions in which those assets are subject to probate. Now, you're in Argentina, and so one issue that comes up quickly is the issue of real estate, because real estate will always be probated in the jurisdiction in which the real estate is situated, right? And if you are not a resident and domicile of that country, it does raise the question, well, shouldn't I have a specific will in that country for that asset? No, generally what we would say is recognize that some assets may not be subject to probate in the country of domicile of the decedent at death, and then have a provision in that will to cover that asset. So you die a domicile of Argentina, have your Argentinian will specify how the US real estate would be probated, or the reverse. Now, in a country like Argentina, you may be eligible to not have things like US financial assets probated in Argentina. And then you're in a situation where you have, you're going to apply for US jurisdiction in terms of probate. And then the question is, how do you apply the rule for your Argentinian real estate? And so that can get rather tricky if you're trying to avoid probate in your country of residence, where you might be a domicile at death. But other than that, usually the issue of having assets such as real estate that are subject to probate resolution in a country other than the country in which you die at death can be solved even using a single will. So I do believe that in almost all cases, a one will is the right case. You can find good expert legal opinion that recommends the use of two wills. I don't think it is almost ever really the right recommendation, and can almost always be avoided by having the one prevailing will set up properly to address all assets. But I do recognize that some recommendations come from various authorities to use two wills in certain circumstances. Anything you want to add there, Roger? That's something that comes up all the time.
Yeah. What I'd add to that is, if you have multiple wills set up together simultaneously, referring to each other, that has the most likely chance of working. The problems arise where you have a will set up by someone on for you in Argentina, and then you go and talk to somebody else and they set one up for you in the United States, or the other way around. Because wills generally start out with statements like, "This is my last will and testament, and I hereby revoke all others." So that can lead to significant complications when you find out your most recent will in one country claims to revoke all other wills in all other countries. So coordination, I think, is the key there. And the most straightforward way to get coordination is to cover everything in one will.
Right. All right. Brendan writes, I'm an American citizen living and working long-term in the Netherlands. If I inherit from my American citizen's parents who live in the US now, will I pay Dutch, American, or both estate taxes? Okay, Brendan, good question. Netherlands is one of those countries that does not impose its inheritance or estate tax laws on bequests from abroad. So you would not owe anything from your parents' estate. Now, your parents may owe something in the US if their estate is above the $11.7 million exemption, or for the two of them, they can double it to almost $24 million, $25 million of exemption amount, right? But that would be their issue. But you would not owe anything in the Netherlands. All right, Spencer writes, Spencer, this refers to a previous question I see, but I can't quite remember the previous question. So
yeah, it was a woman in France whose second husband had died, but he had children to whom she wanted to leave the assets. And the suggestion is that if she adopts her stepchildren, and I'm not sure at all what the rules around that are. It seems to me everyone's very much adults at this point, that then they would be her children for French inheritance tax purposes or inheritance law purposes. So I mean, that could be a good suggestion. Do you want to adopt stepchildren?
all right, great, thank you. All right, Dulce writes, my husband and children are US citizens. We live in Switzerland and own assets only in Switzerland. Will the children have to pay US taxes on the inheritance? Okay, as long as those, no. So the US has an estate tax, not an inheritance tax. So the beneficiaries of an estate never pay the tax. The only question you have to ask, Dulce, is your estate subject to US estate tax? And it is possible that it is, given that the US imposes estate tax on US situs assets owned by non-resident aliens. And I'm going to presume that you're not a US citizen, because you specified that your children and your husband are, right, but imply that you are not. So if you have US situs assets, you potentially are subject to US estate tax on them. However, Switzerland is a country with a treaty, so there would be a formula, and unless your worldwide assets exceed the $11.7 million US estate tax exemption threshold, you would not yourself own any US estate tax on your US situs assets. Therefore, your children and husband would receive them. They wouldn't pay anything. You wouldn't pay anything. There might be Swiss inheritance tax due, depending upon the canton you live in, but that's another question. I hope that that answers that question. All right. Denise writes, Roger, hello. I didn't quite understand the distinction in the common scenario U.S. citizen NRA spouse between the $11.7 million estate tax exemption. So this amount can go to the NRA spouse without, but NRA spouse only has $60,000 exemption. What does this mean? Thanks, Denise. Great. Roger, please clarify this. This is so confusing to people.
Yeah, sure. All right. So we have two individuals, U.S. citizen and non-citizen spouse, also non-residents. So the U.S. citizen, their estate can pass $11.7 million to their spouse without U.S. estate tax. Now, the other way around also happens without estate tax from the non-resident, non-citizen spouse to their U.S. citizen spouse. Now, however, if, let's say the U.S. citizen dies first, they've got an $11 million estate, it goes to their spouse, no U.S. estate tax. And just to keep it simple, let's say it's all U.S. real estate. Now the U.S., the non-citizen, non-resident, the non-resident alien spouse then dies and their beneficiaries are other non-resident aliens. Their exemption is $60,000. So their estate, which owns this $11 million piece of US real estate, only gets the first $60,000 of that exempted from US estate tax, and the US estate tax on the rest will quickly rise to 40%. So the exemptions, the limits apply to the estate of the decedent, not to the recipients. So 11.7 million goes with the US person and $60,000 goes with the non-resident, non-citizen.
Right, but you can get around the $60,000 limit if you live in a country with a treaty, generally, right?
Yeah.
All right, great. Shirley writes, when I begin receiving RMDs distributions from my US retirement account, traditional Roth 403B, will it be taxed here in Japan? Yes, Shirley, those distributions are taxable in Japan, absolutely. All right, Roberto writes, P.S. everything in our name or IRAs. Forgot the question earlier from Roberto. Sorry about that, Roberto. Okay, Mr. Mack writes, what would be the tax consequence on a beneficiary if an inheritance were directed to a discretionary spendthrift trust from a foreign donor?
So that depends. So if it's a discretionary spendthrift trust that is a US domestic trust, and there would be no tax consequence on the beneficiary. The trust and/or the beneficiary may be liable to income that the trust earns in the interim, since it's set up and funded. But there's no obvious estate tax issue that I see there. And I mean, we're assuming that the beneficiary is in the US.
All right. Next question from Mirali. I'm a US widow in the UK, a dual national. I want to leave my estate, including my UK home I share with my husband, to my grown British stepchildren. My securities are in the US with Schwab. What are the implications, please? Roger?
Yeah, so I mean, simply unless you're over the threshold, you're going to be subject to UK inheritance tax only. Well, yeah, that'll be the effect. You'll be subject to UK inheritance tax. You get two different allowances. You get the 325,000, and then you get the
that's in the UK allowance.
Yeah, and then you get another 175, I think it is, for the property going to your children. Beyond pounds, yeah. And beyond that, you'll pay UK inheritance tax on the balance.
Right.
Because it's called inheritance tax, but it's actually paid by your estate. The fact that you've got securities in the US, I mean, they'll be included in your UK estate, but there's nothing special about that.
Right. Okay, Julie writes, does Switzerland recognize US inheritance laws similar to EU 650/2012? No, there's not any specific way to elect the US rules in Switzerland, but Switzerland is very liberal in allowing US wills and even US trusts to determine how assets are distributed, as long as it does not contradict anything in the applicable Swiss rules of succession, which are themselves very liberal. So you're generally okay there. Michael writes, if a US citizen gives up US citizenship as a covered expat, are there any US inheritance tax implications if their heirs are not US citizens? No. The quick answer here is Michael, no, they're not. You're thinking of when a U.S. citizen inherits from from a former U.S. citizen. Yes, there is an inheritance tax. But if a former U.S. citizen leaves their assets to a non-U.S. citizen, there is no inheritance tax there.
Assuming these are all non-U.S. situs assets.
Yes. Well, yes. Then good point. There could be U.S. tax on U.S. situs assets, as we've discussed many times. All right. Kari writes, thank you. This webinar has been incredibly helpful. Excellent. Thank you, Kari. Hervé writes, American citizen resident in France, estate for US-based parents. Parents want to use a trust for financial accounts. Is it okay to have the trust have the estate as the sole beneficiary? French resident would inherit from will and not from trust directly. Hervé, okay, so basically the question is here, an American citizen resident in France receiving an inheritance from US parents. France generally will not tax that inheritance, right? The trust structure, in our experience, if it's properly managed and it's a pass-through, as most living trusts are, do not create a problem with this. But even better, not to have the trust at all, and you imply this French resident would inherit from will and not from trust directly. So yeah, you're not going to have a problem in France in that scenario. You will not owe French inheritance tax. All right, M writes, I'm a US dual Canadian living in Canada. I have investments in the US and a rental property in Israel. I have 2 children under 18 that have US, Canadian, and German citizenship. I currently have a will in Canada. Do I need to set up a proper will for the foreign property in Israel? Are there any special estate tax considerations to make? Okay, so US, Canadian citizen living in Canada. So this is kind of a Canadian law question, but I think probably, I don't know, Roger, how do you want to?
Well, I mean, I do think this is a Canadian law question. From the US perspective, depends on the size of the estate really for a tax liability. From a Canadian perspective, I think a Canadian will that makes provisions for the property in Israel. But again, that's also going to be a question of how will the probate process go in Israel with a Canadian will.
There could be Canadian treaties with Israel that have an impact on this scenario.
Yeah.
All right, great. Okay, let's move on. Lori writes, am Australian US dual citizen and expect to inherit from my US parents, hopefully not too soon. Is it an option or good idea to simply ensure US residency domicile for the year when the inheritance would be received. No, not necessarily, Lori. Australia does not have an estate tax or inheritance tax. And generally, you can receive inheritances as a resident of Australia without owing anything. I think, though, where you may have an issue is with the cost basis on the inheritance moving over for Australian tax purposes and creating a potential future tax liability in Australia. But I can't recall the rules on that. We would have to consult some of our other advisors who specialize in Australia. Roger, anything you would add there?
Well, I mean, so is your question there, what happens if you die in Australia ultimately, then yeah, if it was going outside Australia, it'd be subject to Australian income tax. But if you're just inheriting in Australia, then you're planning on remaining there and your beneficiaries are in Australia, I don't think you need to worry.
Yeah, I think one thing you may want to do is ask the assets to be sold by the estate and have you receive only cash. And that will mitigate any risk that you would be, that the original cost base of the assets would transfer to you. All right. Okay, Maya writes, okay. I wrote before that U.S. Italian national family living in Italy with Italian family. I think I am okay in terms of inheriting my parents' estate as I am an executor of a living trust that I will then direct to me or me and my family. My question is about whether it would be a good idea to direct some of my parents' estate directly to my children. Can I avoid some Italian taxes by doing that? Having some funds skip me and go directly to them. The second issue is how the irrevocable grant or trust set up by my aunt will be treated in Italy when it gets to me.
So the first thing you're going to need to pay attention to is whether or not you're going to attract generation skipping transfer tax on your parents' estate, which would happen on the when the trust kicks in, because that's effectively what you would be doing by skipping to your children. It may well avoid any Italian issues if they receive assets you never inherited. And then I think we kind of talked before that the irrevocable grant or trust is not something you want to be running as trustee in Italy. I would want to, I'm fine to be a beneficiary of it, but I wouldn't want to be a trustee.
Right. All right, moving on. Next question from Barbara. I am a U.S. citizen living in Spain. What issues arise if I'm an executor of my parents' U.S. trust? Okay, Barbara, so let me answer this one. Generally, trust would not be recognized in Spain, but if the trust is simply, as it probably is, I don't know for sure, but just a standard U.S. living trust, it's essentially an estate resolution tool, right? And therefore, the problem in Spain is trusts, if they are irrevocable, they can become third parties, right? And then punitively treated for Spanish inheritance tax. And Spain will impose an inheritance tax on assets, depending upon what region you are in Spain, will impose an inheritance tax on assets received from a U.S. decedent. And it will depend to some extent on what your relationship to that decedent is. So if the trust is simply a probate, a living trust, it's coming from your parents, but it's just there to speed up the probate process, then you can probably easily declare to Spain that this is an inheritance from my parents, pay whatever taxes due. But if it is structured to be an irrevocable trust, now you're going to find that you're in a situation you're potentially inheriting from a third party, and you're going to be treated more punitively in Spain. So those are the issues I think you have to sort out. All right. Fred writes, Roger, I'm a dual Finnish American citizen living in Thailand with my Thai citizen spouse. I have brokerage accounts and IRAs in the US, as well as an apartment in Sweden totaling less than $1 million. My priority is to make it as easy as possible for my wife to inherit rather than saving on taxes. How can I do this? If possible, I would also like my Swiss citizen sister and Swedish nephew and niece to inherit some assets from me. Okay.
All right, so from a US perspective, you're not going to have any tax issues. I would, well, I would think my first caveat on this is make sure that there's liquidity for your spouse. So preferably assets in her own name or perhaps in a joint account, joint brokerage account. She could also certainly be beneficiary of the IRA from a US perspective without any issues. You're then, I'm afraid, going to have to get Thai advice on on what your will needs to say, and that it will be effective in ensuring that the assets pass as you want them to. The apartment in Sweden is going to devolve according to Swedish probate, so you'll need to consider that in your Thai will as well. If you don't need the apartment, maybe you liquidate it and now and have the assets available in liquid form to be passed on to whomever you want to benefit from them.
Right. In Sweden doesn't have an inheritance tax. Switzerland wouldn't. So I don't think that there's going to be tax on the inheritees in Sweden or Switzerland. Well, there's no beneficiaries in Sweden, only in Switzerland, right? And Thailand. So I think most of these assets are going to pass. The only question I would have is there going to be a tax on an income tax on the Swedish apartment? It's possible. All right, moving on. Christopher writes, I'm a US citizen and wife is dual US Brazilian citizen, no kids. We currently reside in Brazil for retirement. We have had the majority of our assets in the US and are thinking about what type of estate planning documents we need in place. Wife and I are each beneficiaries of our retirement accounts, and I own rental property in my name in California. What are the inheritance tax implications for Brazil? Thank you. All right, so let me answer that one. We've worked with quite a few clients now in Brazil. If you are a resident in Brazil, Brazil is a country that will seek to impose its inheritance tax on your worldwide estate, right? That would include the value of assets held outside of Brazil. So while your US real estate may pass according to the probate laws of the US, it's still nevertheless going to be subject to inheritance tax in Brazil. So you're not probably going to have a US issue, right? Unless your assets exceed the $11.7 million exemption. So you have the full $11.7 million exemption to pass assets onto your kids without there being a US issue. So I think, Chris, your real issue here is understanding what your Brazilian liability is going to be at your death. And so, and you will find that you're going to have to potentially pay on your worldwide assets if you die domicile of Brazil. All right. Moving on, Denise writes, just heard Mr. Healy's reply about the $60 exemption, but I still don't understand. Can a non-US citizen spouse inherit $11.7 million and not pay US tax on it? Yes.
From a US citizen.
From a US citizen.
Yeah.
Yes, that is correct. Yeah, it's very hard to get that clear. Ellie writes, can you please talk more about U.S. tax implications of receiving inheritance from a UK trust? Would high U.S. taxes be owed on receiving inheritance from a UK trust? And what tax forms would be required?
Right. So there's no inheritance tax in the U.S. If you're the beneficiary of a UK trust, you would need to report annually on forms 3520 and 3520A. You may, depending on the circumstances, be subject to income and capital gains tax on what is being earned by the trust. But again, it depends. Trusts. A trust is not a simple thing. It can have lots of different provisions. No two trusts are necessarily the same. So a lot will depend on the trust, what it owns, what it earns, and what it distributes and whether or not it distributes. But there's no U.S. inheritance tax per se.
Right. Okay. Agreed. Richard writes, I'm an American residing in Canada. My spouse is Canadian and my children are dual citizens. I have an IRA and an investment account. Do I need a U.S. will, and what would be the tax implications? No, you do not need a U.S. will. I would recommend you do not have a U.S. will. You should have a Canadian will. The tax implications are that you can pass your IRA to your spouse and your children under the rules of the U.S. inherited IRA assets. It would pass to them, and potentially then when those assets are eventually distributed out of those IRAs or inherited IRAs, there would be income tax due in Canada on them. All right, Tanya writes, okay, no assets in the UK other than pension contributions. Okay, that's referring to something earlier, sorry. Okay, Elizabeth Matheny, we live in France, right? She's referring to the earlier question where we made the assumption that Elizabeth was in France. It wasn't clear. All right, Dirk writes, I do not understand the European Certificate of Succession. Do I have to sign a contract before I die? Do the inheriting person decide to use this? Do I have to do something in advance? Thanks, Dirk.
Yeah, so Dirk, this is basically the result of you making an EU regulation 65 or 650 2012 election in your will, in your European will. So I'm not sure, I don't immediately recall where you are, but in your European countries, your will, you make the election to have the succession laws of your citizenship, and if you're US, you need to pick a state, apply. That will then, when probated in that European country, will create this European Certificate of Succession, which is something that comes into force under that regulation. So your inheritor doesn't need to do anything. Your executor would take care of it. And as for doing something in advance, yes, you have to make the election in your will.
Right. Moving on to Spencer's question. If an American citizen living in the US receives an inheritance from US parents, would Netherlands impose a tax on the inheritance received? What about grandchildren? If an American citizen living in the US receives an inheritance from US parents, would Netherlands impose a tax on the inheritance received? No. What about the grandchildren? No. Okay. Netherlands is not going to impose its inheritance tax on US citizens living in the US. I seem to be missing something there.
I think he means a US citizen living in the Netherlands. who receives an inheritance from US parents or their children, everyone living in the Netherlands receives.
No, Netherlands does not impose its inheritance tax on assets received as an inheritance from other countries, from the US. So no, Netherlands would not impose a tax. Oh yeah, okay, yes, I see. There's a correction there. Got it. Okay, very good. Okay. Ann writes, excellent informative webinar. I must go to another meeting and I'm looking forward to the next recording. Excellent. Thank you for being on the call, Ann. All right. Suraj writes, would that be a foreign grantor or non-grantor trust? Suraj? Okay, Suraj has an asset that you said would be a foreign trust from earlier.
Right. So I don't remember the entire detail, but a grantor trust is one where the grantor essentially retains the ability to control the assets and therefore is also liable, sort of for the income taxes of the trust. And a non-grantor trust is one where the grantor has not retained sufficient powers. So whether it's going to be grantor or non-grantor depends on the trust. So for example, a living trust is a grantor trust. So if you've taken a living trust away, then that would be a foreign grantor trust. Oh yeah, so Suraj had the one about the DIFC Foundation.
Yeah, right.
Again, without reading the foundation documents, I couldn't tell whether it was grantor or non-grantor. It's probably grantor because it's probably very simple.
All right. Okay, great. All right. Vidya writes, are there any treaties between India and the US? If I have property in India and I spend 50% of my time there and 50% of my time in the US as a US citizen, what is the best way to pass the Indian real estate and investment portfolio to my US citizen children? Okay, so Vidya, the US has an income tax treaty with India, but not an estate tax treaty. So if you are living in India half the time, the question is, are you triggering so the US is easy, right? You're a US citizen. So so the US is going to impose its income and estate tax on you, whether or not you're in India or the US as a resident. But the question is, does the Indian law apply? And so we'd have to look at the residency rules in India, but it's probably something like 183 days of 365. If you spend there, you are subject to all of the rules of India. India does not have an estate tax or an inheritance tax, so your children should not owe estate or inheritance tax on your passing on assets in India or the US, except to the extent that you might owe US estate tax. You might owe US estate tax if your assets exceed the $11.7 million US exemption amount. But presuming that's not the case, you probably don't face US or Indian estate tax or your beneficiaries in any of these circumstances. All right. Yes, Ellie, the trust would cease to exist after paying out following my father's estate. So yes, so it's not a irrevocable trust. It's just a will substitute for the resolution of the estate, so probably will not be treated as a trust by a foreign taxing authority. Yes, Michael writes, is a U.S. security, for example, shares in Coca-Cola, considered a U.S. in situ asset? In situ, I think that means a U.S. situs assets. Yes, Coca-Cola is a U.S. situs. Shares of Coca-Cola are a U.S. situs asset. All right. Nancy writes, if my daughter, who is a U.S. Canadian citizen living in Canada, worked with you, could she open accounts for her 2 U.S. Canadian citizen kids so that we could gift the grandchildren $15,000 per year as part of our gifting plan? Otherwise, her children have no U.S. accounts as banks and Vanguard asks too many questions to open them. Okay, Nancy, good question. Unfortunately, of all of the countries in the world right now, effectively Canada is the only one, along with Iran and North Korea, where we cannot take clients and we cannot open up accounts. So unfortunately, the answer is no. We cannot work with your daughter who is a resident of Canada.
But that doesn't stop you making gifts to them. You can cut them checks and they can put them in their Canadian accounts.
Right. All right, great. Anthony writes, I'm a US citizen living in Austria. My US citizen brother lives in South Carolina. Some of his assets are in South Carolina Revocable Trust, of which I am the trustee and the primary beneficiary. Are there any issues I need to know about, especially if he predeceases me and I inherit the estate? Yes, I think there is here, Anthony. We've gone through this issue with Americans in Austria who have received inheritance from the US. Normally, they would not be taxable as inheritances because Austria doesn't have an inheritance tax when receiving an inheritance from a direct lineage parent or something like that, or relative. But when a trust intervenes, that can change the scenario. So get good Austrian legal advice on any risk that that inheritance is going to end up being taxed in Austria, where it probably otherwise wouldn't be because of the trust. All right, James writes, I've heard pensions are excluded from the $325,000 threshold in the UK. Can you confirm? Roger.
Yes, but pensions are deferred income or deferred compensation. So the beneficiary, depending on how old the pension holder is, may end up paying income tax on them when they take them out.
Right. Okay. Well, yeah, and excluded from that. Well, it's in. I would restate it's like in addition to, right? You can exclude the pension in addition to the $325,000 exemption. Yeah. Right. Just to clarify there. All right. Sharon writes, I have a U.S. revocable trust with my only daughter as the recipient when I die. Can she simply inform them and have my trust equity simply transferred to her name? Generally, yes, Sharon. That's the way trusts work. After she establishes who she is and that the trust was properly established, yes, those assets will pass directly to your daughter. With respect to U.S. rules, you're not implying any other jurisdiction that may have a claim in this, Sharon, and that could change it. No, so next question clarifies this. Sorry, I should have read them together. She currently lives in Singapore, where she is a tax resident. I live in India as a tax resident. We are both U.S. citizens. Can she simply transfer the revocable trust to her name with documentation of my demise? Well, if these assets are in the U.S. and they are in a U.S. trust, that will probably happen. It's probably not a problem for her in Singapore. I would be a little concerned that this is not valid under Indian law. Even if you're able to execute it, you want to check and make sure that this does not violate any Indian law that someone could then come back and challenge. Roger?
Yeah, that would be one of my concerns. And then the other kind of question, the mechanical one here, is transferring the trust. You don't really transfer the trust. You would transfer the assets into an account in her name. If she wants to have her own trust, then again, that's a matter for counsel in Singapore. There wouldn't be a U.S. problem, but there might be an Indian or a Singapore problem with doing that. But if the simplest solution, I think, would be for her to open her own account in the U.S. and have the assets transferred in there. I actually don't know what India would make of a trust in that circumstance.
All right, moving on. Next question. Celia writes, sorry if I missed this. UK-US citizen, soon inarguably domiciled in the UK, so UK-US citizen domiciled in the UK, UK-only spouse. Can the IRA pass to the UK spouse? Will he then become subject to US taxes or just UK taxes? Right.
So,
Roger?
yeah, so the distributions from the IRA are, deferred US income and will be subject to US income tax. They are also subject to UK income tax. So yes, you're subject to both.
Yeah. So Celia, your spouse would start taking distributions from that IRA. They'd pay the tax in the UK, and then that tax would be available to offset what's owed in the US. No, actually, I want to revise that though. Yes, there would be no tax due in the US, right? Because the US-UK double taxation treaty gives the right to the country of residence complete taxing authority, right? So the US source would not be subject to US taxation if received by a non-US citizen, UK domicile, right? So yes, do you agree with that, Roger?
I'd want to double check that. I mean, normally what you would do is you'd end up getting withheld out of that account, but
yes, but I think you could cite the treaty and eliminate the withholding.
Eliminate the withholding. Yeah.
Yes. Yeah. So Celia, yes, your spouse is going to inherit that IRA. The money that will come out from the IRA will be taxable to him in the UK only.
As income.
As income tax, but you're going to have to get that account in the US properly coded with a W8BEN form when he inherits it. All right. Mark writes, comments, not question. Many thanks for today. My takeaway is very complicated and you won't be out of a job anytime soon. Yes, indeed, Mark. Thank you very much. Glad you found it helpful, if not unconfusing. All right, Janet writes, okay, we've still got quite a few questions here. We're really gonna start going fast here because we've been at it for 3 hours now. All right, Janet writes, hello, I'm a US citizen living in Italy. I am 50% owner of a house, with the other part being 2 daughters, heirs of my former husband. One heir is my daughter, US citizen, and the other heir is German. I had a written accord with my husband to give up my part of the sale of this house directly to heirs. Since it's still in my name on the deed, will I be subject to capital gains even if I gift it immediately to heirs? Roger?
Yes. If you gift it to them before you sell it, then you would be able to get a different valuation on the gift and use up your gift tax, and then they could take they would get your basis. And I'm thinking of the U.S. person here, and then they would pay all of the capital gains on, say, their half share when it was sold. But if you wait until after you've sold it, you'll have to pay the capital gains tax, no matter what you give to it's a totally separate transaction.
All right, great. Okay, Patricia writes, as a dual US Spanish citizen living in Spain with assets in both Spain and the US, do I need a will in each country in order to leave my assets to my son, who also has dual US Spanish nationalities and may be living in either Spain or the US at the time of my death? Very simple answer, Patricia. You do not need 2 wills. You should have a Spanish will only. All right. Next question from Hervé. Thank you for this great webinar. Are US 403Bs and IRAs considered as trusts in France? No, they are not, because they're qualified by the treaty between the US-French double taxation treaty. So where they might technically be trusts, that is overridden by the agreement to treat them as pension accounts. All right. C writes, should one have a U.S. will for U.S.-based assets and a Swiss will for Swiss-based assets, or one that will cover both? Answer, you should have one will that will cover both, and that will should be written in the country in which you are a domicile. Are there any benefits to having assets, brokerage accounts, excluding real estate in one country, Switzerland, for example, despite the high fees? No, there are not. If you are a U.S. citizen, I would not recommend holding your investment assets in Switzerland. Aside from the high fees, you potentially risk being sold products that will be passive foreign investment companies or foreign trusts and will create all kinds of U.S. tax complications for you unnecessarily. And C follows up, thank you for hosting this informative session. You're welcome, C. All right, next question comes from Cheryl. New question, I'm a US citizen living in Germany and have a German will. I will be leaving my estate primarily to my niece who is a US citizen living in the US. My estate is under the $11 million. Will she have to pay any German inheritance tax? Yes, okay.
Then she follows up.
Oh, I see. I have real estate in Germany and securities in both Germany and the US. Okay, so there is a provision in the US-German estate tax treaty that exempts from German inheritance tax US assets left by an American citizen living in Germany during the first 10 years of their residence, right? So Cheryl, you have one option here. If you've only been in Germany for less than 10 years, it is possible for you to cite this provision of the US-German estate tax treaty that would exempt your US assets from being subject to German inheritance tax as you leave them to an heir. However, while that language in that estate tax treaty seems quite clear, we have had German tax experts who say that it is not acknowledged or accepted that way by German tax authorities. But I can tell you this, if you've been in Germany for more than 10 years, yes, those assets are going to be subject to German inheritance tax. All right. Right, and Germany will impose their inheritance tax on your worldwide assets with that exception. All right, Hervé writes, I already asked, but not sure it got in the queue, sorry, for an American living in France. His US parents want to put financial accounts in a US trust, okay? That could create estate taxes in France if the French resident is a beneficiary of the trust, not trustee. One solution could be to make the estate the sole beneficiary of the trust. The French resident would inherit via being a beneficiary on the will. Is this legit? Thanks again for a great seminar.
Yeah, so I mean, I think what's really confusing here is that in general, you put your assets into a trust to avoid probate, because then it passes without the need for it to go into your estate, your probate estate, and pass under the terms of your will. So normally the will would say, you know, the assets that are left in here go to the trust, and then the trust deals with it. So I guess my big question here would be, if you're setting up a US trust, the beneficiary of which is going to be your probate estate, and then the assets in your probate estate will pass by operation of your will, why take the step of putting in the trust? Unless, you know, there are multiple heirs and you're saying, well, you know, our will leave everything to one of our children who lives in France, and the the trust will distribute the rest of the estate to the other children, and that might be a good idea. But I don't see anything illegitimate about doing it. Just have to
Right.
go through the logic of doing it.
Right, great. Anthony writes, if one has a foreign will in a foreign language, should one have a translation in English? If so, who should do the translation, and in which country should the translation be done? Good question, Anthony. You know, different countries and different authorities will have different standards for this. So I can tell you, for example, Schwab sometimes will require to see the will in understanding who is properly the beneficiary or the executor. That's what they're concerned about. Schwab will, for example, take the original and they will pay to have it translated themselves, right? So they will not accept someone else's translation. And so, you know, different courts could have different standards for this. So you should really look and see, you know, where the assets are going to be probated, who's going to be reading this will, and ask what their standards are.
Yeah, and the only sort of thing I'd add to that is obviously these things are easier to do when you're the one doing it, not your executor or your kids, and you're not in any kind of a rush. So if you have a, you know, I think you're in Austria. If you have a will in German, talk to the consulate as to, you know, who's an acceptable translator. Have it translated and certified, and then certified by the consulate, and then, you know, just put it in your document. So you've got a good English certified translation usable in the US. Even if, you know, a custodian says no, they'll get their own translation. You might need it for other purposes.
Yeah, that's exactly right. I totally agree. All right. Sylvain writes, I'm a US French citizen living in the US. What is the most tax efficient setup for getting my French parents' inheritance, including French real estate and stock shares with my French siblings living in France? All right, well, Sylvain, there's not much I think you can do about this. Your parents' assets are going to definitely be subject to French inheritance tax before they pass to you. And the US will not tax any of it. So I don't know that there's a lot that you can do other than whatever strategies that your parents may employ to mitigate what they owe in terms of French inheritance tax. Roger, you want to add anything to that?
No, I mean, I don't. I don't see that there's much effect you can have on it. You'll have to go through the French notaire to get anything transferred to you.
But you're not going to have any U.S. tax due. I can tell you that. All right, Elizabeth writes, another question. Sorry, I know it's getting late. I'm a dual French-U.S. citizen living in France. Parents are U.S. citizens in New York. Upon their deaths, would it be taxable in France at all, or only estate tax in the U.S.? Good question, Elizabeth. We've been over this quite a bit now, but yes, you're correct. There would be no, France does not tax inheritances from the U.S. As long as the assets are passed and they're not put into a irrevocable trust. So they should wrap up the estate, pass you your inheritance in terms of a resolution of the estate, and you will not owe anything in France. Right. All right. Maya writes, is the U.S. the only country that steps up basis of securities once they are inherited? Roger?
Probably
not the only one, but it's.
Yeah. I'd be always hesitant to say the only. But I mean, it's a very common feature in the US and I guess not very common outside.
Right. Thank you, David, for a very informative webinar. You're welcome, Chris. All right. Kyoko writes, hi, David and Roger. Thank you for your informative webinar. Question, my husband and I live in Barcelona. Our grown children live in the US and in the UK. We are all US citizens. I understand that In Spain, succession is possible only after the estate tax is paid. We have financial assets and U.S. financial. We have financial assets in the U.S. and real estate and financial assets in Spain. If all of our assets are included in our estate, is there a way that our children could pay the Spanish estate or inheritance tax without liquidating their own assets?
Yeah, so I mean, I'll make a distinction here between, paying estate tax and distributing the estate. Normally, estate tax is payable by the estate out of the assets that it already holds, and then once all those, once all the estate's formalities and its taxes are paid, the executor is then free to release the remaining assets to any beneficiaries. Now, if there wasn't liquidity, the estate, may be able to borrow against the assets to pay the taxes. But it's not normally a problem, whereby the children need to sell something to pay an estate tax to receive an inheritance. Normally the executor takes care of all that.
Right, but if there's not enough liquid assets, they could be in a situation where they do have to sell some of those assets.
Sell an asset.
With the assets. So maybe if you have a daughter who's outside Spain, maybe that daughter, in anticipation of this big tax due, maybe they could have an insurance policy they could pay it from outside of Spain without that payment becoming part of the taxable estate in Spain. I don't know.
Yeah, I mean, there's definitely a possible insurance angle there, but yeah, I think that the likely solution is that some of the financial assets would be liquidated to pay estate tax.
Yeah, I would think so. Okay, all right. Richard writes, if you have a joint brokerage account with your non-American spouse and take your name off of the account, are there tax implications? Good question.
So very likely. So, but it depends. So I'll kind of run through a scenario. You have a brokerage account in your own name, with $1 million in it. You add your non-resident, non-citizen spouse to the account. At that point, nothing has happened. You have what would be considered an incomplete gift to your spouse. The gift would complete if your non-resident, non-citizen spouse withdrew assets from the account. And then if they withdrew more than $159,000, you'd have a reporting requirement. If you simply add their name on it and then take your name off it, it's when you take your name off that you would complete the gift to them of all the assets in the account, and that would be subject to US gift tax, at least reporting requirements, and maybe using some of your lifetime exemption.
Great. All right. Ellie writes, U.S. permanent resident lady again, who may inherit from a UK trust. Okay. If I am taxed income or capital gains as a result from inheriting from a UK trust, would the US tax rates be nasty? Right, so Ellie, if you are a US recipient of a foreign trust, okay, in general, either that trust must be reporting and paying tax to the US government in respect to the US citizen who is a beneficiary, or you must be. And yes, tax rates are more punitive in the US from a trust. So yeah, I would go and get this resolved with a good accountant who understands how a foreign trust with US beneficiaries is taxable, because this is, again, one of those scenarios where we've seen it really, really blow up because nobody realized that the US citizen beneficiary, by simply being a beneficiary of that trust, even if they weren't getting distributions, was creating a US tax liability for a long time, and then not having paid it creates penalties and interest and all kinds of complications. All right, okay. It has been so informative, can't stay longer. Okay, well, great to have you on, Karen. All right, Patricia says thank you. And Anthony writes, okay, one more question here from Anthony. To clarify previous point, I'm a US citizen living in Austria. I understand that my NRA spouse, also living in Austria, can inherit my US assets tax-free up to $11.7 million. Can inherit any assets tax-free up to $11.7 million in the US. I mean, with US, so that's the exemption amount on your worldwide assets, Anthony. For the when she passes, will our 3 children, dual US German citizens also living in Austria, inherit her US-based assets tax-free? Good question. Roger, can you clarify that one?
So
now the non-resident alien has inherited all of these assets. Some of them are US situs assets. What happens when she dies?
yeah, so well, let's just make the case simple and assume that all of the US assets are US securities, US stocks and bonds and ETFs and things like that. Then relying on the US-Austria estate tax treaty, none of those assets would be considered US situs assets or subject to US estate tax in the hands of a non-resident, non-citizen resident of Austria. So no US estate tax, but that does not mean there wouldn't be taxes imposed by Austria and or, well, they're all living in Austria. That doesn't mean there aren't tax, they'd just be part of our Austrian estate. So whatever tax liabilities there are in Austria would apply.
Right, but Austria doesn't have an estate tax or an inheritance tax. So aside from possible income tax on untaxed income, there wouldn't be any Austrian estate tax either. All right, so Cheryl writes, amazing. Thank you so much for the presentation. Incredibly generous of your time to do the Q&A for 2 hours. You are welcome, Cheryl. And guess what? We have reached the end of our presentation. And we are so happy that all of you joined. And I want to quickly remind you again that we are having another webinar on April 1st on college savings, and then again on May 11th when we're going to go into US, UK investing and financial planning. But for now, I want to thank you all for attending, and I want to encourage any of you who need further elaboration, because oftentimes it's very difficult to answer these questions because we don't have all the information we need. Feel free to inquire to us, email us directly or through our website. Roger and I would be happy to answer, as would the other advisors, and we will look forward to seeing you at the next webinar. Thank you.